Sorry.
For orders item number 1, CMAPL 545 of 2020.
Item number 1, IA number 333 of 2023 for condonation of delay. Some notices were issued to the opposite parties, but some have been made, may be considered to be sufficient, and in respect of the rest, fresh notices with the correct address, I may be permitted to take. The Lordship may kindly see the opposite parties to whom notices were issued. That is in respect of opposite part number 8, 9, 10, 19, 20, 25, and 29 may be considered as sufficient because they have received the notice personally. But in respect of others, I may be permitted to take press notice with correct address.
No, whether in the writ proceeding notices were issued.
Notices were issued earlier.
Who are the those opposite parties?
So Lordship, opposite part number 3, 4, 5, 6, 7, 11, 12, 13, 14, 15, 18, 27, and 28.
Then your CMAPL cannot be
So Lordship, there is a delay of 10 days.
10 days, that can be done. That is no issue. Delay, there is no, in one of the judgments. Joint Commissioner,
Instead of calendar circle, it should be
Matter from the list, item number 13. I am permitted to withdraw the same since I have filed petition to recall the order of the imbue.
Item number 26 and
13. 13. Retapel 13.
Two matters.
there are two matters.
No, I think one matter.
One.
The other matter is single bench matter.
Item number 26 and 41 belongs to this list.
Interim order.
41?
Item number 26 and 41. Can be taken up today.
Oh, no.
26 is a matter where the petitioner is not getting any pension since 2007.
2007.
Yes.
So you will have to satisfy us that other cases are not as important as your cases.
Pecuniary.
Pecuniary, every matter is urgent. We will see if it is possible, we will take up. Otherwise, you will have to, and if you want, we can lay down something as to which are the matters which are more important, which are the matters which are less important. Or you can pass a resolution in the Bar Association that these matters are not important. Please don't make a mention before the court. So we'll see. I'll try.
Maybe pardon, my lord. Maybe pardon, my lord. Item number 14, my lord, of today's lord. This is a matter relating to the Orissa Public Service Commission writ appeal, where lots of, my lord, we had taken the liberty of serving the copy on the counsel who was appearing in the court below, my lord, Lawrence Single Judge. But the counsel for the petitioner, my lord, says that notice has to go
All right.
because he will not receive the copy, my lord.
All right.
Copy, in fact, I had served the copies, but he
He's
said that
present
he's present here.
He's
Also
present here.
served, have no contact with.
Right.
Yes, sir. Yes.
There is nothing wrong in it. You cannot accept notice unless
Right,
instructed.
You're absolutely.
But you cannot press. Is there any contempt application pending?
No.
No.
The examination is passed, my lord.
All right. Yes.
May I request you also fix up a returnable date so that we all selected candidate we are waiting for the.
Item 14.
Yes,
That very much.
Let the matter come. Let the matter called for. Yeah. You have called.
Only to.
Let item number 14 be called. We'll pass.
Yes, last one.
For judgment, item number 1.
Mr. Rao, we are not happy. We have dismissed the writ application. We intended to impose cost. We have not. Because dismissed. Orders.
Matters under the heading of orders. Item number 27.
Item 27. Although there is a delay of 62 days.
No, that you were supposed to verify.
Yes, I
whether
have
we
also
could entertain the
obtained instruction, my lord.
Yes.
Regarding that, one similar matter your lordship had already disposed of. Now, in the case of petitioner, I have already obtained instruction that he has applied and disposed of in the similar manner. But there is a delay of 62 days. No notice has been issued in the application for condonation. My lord, may kindly have a glance to this instruction. It's a case of non-submission of online path, denial of promotion, my lord.
I remember last time
Yes.
you were asked to take instructions regarding
Yes.
because since you have given a one-time relaxation,
Yes,
if he has applied, it will be
Yes.
considered.
your lordship may kindly see the instruction. Para 6, 7 and 8 are important. The same instruction was.
Yes, yes.
Only that delay, no notice has gone.
Delay is for-
Yes, yes, your lordship.
he has any grievance.
Obliged.
So we are condoning the delay, we are disposing of the appeal, and because we are condoning the delay without issuance of notice, we are making this observation that he shall be at liberty to seek modification or recall of the order.
Much obliged.
Item number 28.
Item 28. Last occasion, Ms. Sashwati Mahapatra appeared.
Yes, twice they have taken, once the other council had taken time to file
Objection.
objection. Thereafter, madam appeared, she had also taken
Yes.
time. Maybe she has not reached or whatever.
All delay.
Delay of
415 days.
that is again 100 times.
All right. That sounds good.
One appears for the respondent when the matter is called on 25/9/2024. Time has been granted to the respondent to file objection to the IA for condemnation of delay. One more chance is given to the respondent to file objection if any. This is the case on 7/9/2024 for orders.
So the adjourned matters, item number 2.
Lordship said, called upon me to file again an affidavit which I filed. Affidavit, sir. Your Lordship, if you stated the matter was there about the sealing part, Lord.
I am also filing an affidavit endorsing my no objection to the undertaking given, subject to some correction.
So, Milord, may I just submit at this moment, what I am before your Lordship is a premises where also I was staying. I will not run the hotel or cannot run the hotel unless your Lordships decides in the writ appeal or I gave a consent. But it's the premises in which I was myself saying. No, what is the affidavit? So I want to unlock only.
This
No,
is my,
who locked? The government? Where have you said? Yes, sir. The government unlocked. Lord, may I just tell your Lordships? Kindly see, my Lord, the orders of the.
File affidavit.
Yes, I've given 2 affidavits. I have filed an affidavit and an IA both. Both. I have an affidavit and IA both I have filed.
so that also a prayer is made. Lord, kindly see the
No, we just want to know who blocked the premises.
lock was, my lord, by the order and the intimation by the pollution, the collector, they intimated the collector directed the tehsildar locked in and informed. Tehsildar.
Let us see.
Yes, sir. Kindly see, sir. I've got page, your lordship says, if your lordship is holding that there are two affidavits, IA and the kindly see, my lord, the IA. I've in the affidavit I've said, page 8.
On behalf of the appellant.
Sir? Yes, sir.
This is on behalf of the appellant.
I am the appellant, sir.
This is an affidavit.
Yes, affidavit
there?
and then I. Both the, because I have to make a formal prayer, my lord. Kindly, sir, see in the annexes 6 to the IA, that to the tehsildar, the collector writes to the tehsildar. I've also in Annex 6. In inviting elections, I have to state that the regional officer has issued direction to the proprietor Hotel Sugar for ensure closure. I am enclosing copy of the letter of the regional office and a copy of the letter. I am requested to ensure closure of the hotel
They locked up the main door.
and act accordingly as per the observation of the High Court. Look, that matter which is impugned before our lordships, the Honorable Single Judge. Thereafter, my lord, the tehsildar, that's it. Lordship get it at page 10. In inviting a reference to the collector, he writes, reference is subject above, I am to say, as per your letter of the regional officer, passed by the Honorable High Court, as well as directive of the Office of Collector, closure of Hotel Sorga is completed on 38/2024 at 2:25 p.m. That is the day he locked it, sealed it.
No, where is that?
Sir, no, that is the closure, my lord. That is
The
the
closer means.
he has locked it.
No, closer means he might have gone there and ensured that the hotel is closed.
No, my lord.
So closer has that meaning.
That good. That is the normal meaning.
Just a minute.
Yes, sir. Sir, that's the normal meaning. But fact remains, sir.
One more.
Sir.
So there is a statement, but this is.
Yes, I made-
Appellant. Huh?
Yes.
Huh.
You have the photograph?
Yes, sir. This is
They
the
locked the main door covering iron chain and sealed the same.
yes. They have sealed it. That's no. The pollution board. Like,
That they have not
They do not dispute. That's a fact.
The manner
Yes, sir.
in which it was sealed.
it is sealed, sir. This is the seal in the main gate. This is the seal of the taken photograph.
Yes,
This is the
yes.
seal of the main gate of the entire entrance.
Normal way.
It's a premises, sir. It's a house where I was also living. Of course, I am no more living because of it was sealing.
So when was this done?
This was done on 30 August at 3:30 p.m. 30th of August of this month, this year. 30th of August.
Yes, where do you have this power?
Yes, your lordship, your lordship, day before yesterday asked for me.
Have you given it to him? All right, let us.
Yes, Lord Smith.
In this case, your lordship, the pollution control body written letter to the principal secretary to Government of Forest and Environment Department regarding implementation of closure direction order issued by the state pollution control against the defaulting industries. Your lordship, in pursuance to the your lordship, they've given this letter to the government. The government, your lordship, next page, your lordship, page 3, your lordship. The state of Orissa, my lord, Forest and Environment Department issued a circular on 13/2/2004, your lordship. Yes, your lordship got it. Or directing all the collector implementation of the closure direction order issued by the state government, state pollution control board against the defaulting industries. In enclosing a copy of the letter number such and such, along with the enclosure of the chairman of the state pollution control board, addressed to the principal secretary to Government Forest and Environment Department regarding non-implementation of the closure direction to the defaulting industry issued. I am directed to say that government in the law department was moved for a clarification on the issue. put forth by the SPC board in their letter referred to thereon. Whether the state pollution control board government could include the collector and superintendent of police of the concerned district as parties to enforce the direction of the specially closure order. Opinion of the law department is in the affirmative. Relevant portion of the under Water Act and AR Act, along with the judgment of the Kolkata High Court, have been enclosed for reference. Accordingly, also Lordship 33A and
How can you seal that?
my lord, seal your lordship. Seal is also approved by this honorable court in division bench, your lordship. Your lordship, see page. Yes, ma'am. Page 7, your lordship, see. Page 7, your lordship. Relevant page, my lord. There is a paragraph 8, your lordship. Paragraph 8, your lordship, page 16, your lordship.
Why is the same
Paragraph 8, your lordship. Your lordship got it? Page 16. In WPC number such and such, the petitioner have challenged the sealing of their respective units by the district administration on the ground that prior to sealing of the unit, no so-called notice of the closure were issued to the petitioner board. The board in the counter affidavit stated that notice has been issued to the petitioner to stop operation and to so-called as to why legal action would not be taken for violation of the provision of section 21 and 22 of the Act. The said notice was published in the newspaper pursuant to the petitioner filed the reply stating to shift their unit suitable location. Thereafter, notice under section 31A, their Air Act was issued to the which the petitioners filed the reply. Finally, the board issued direction to for closure of the unit for after giving due opportunity of personal hearing to the petitioner. When the petitioner did not comply with the direction of closure, the district administration sealed the petitioner unit. We have perused the records and found that before the sealing, the unit opportunity was granted to the petitioner.
So where is that?
Therefore,
That
find no merit.
Mr. See here,
Yes, madam.
the order of closure was not being complied with. In that
Here
circumstance.
also, madam. Here also, madam. You see the closure.
Listen,
Yes,
Mr.
ma'am.
Listen. This you have given as closure of some industries.
Yes, madam. In this case also, we have given closure. Annexure 4, your lordship. Annexure 4, page 43. We have specifically asked to please close. He did not comply. Your lordship, see last page 45. Your lordship. Your lordship.
45, you have given us 1 to 16.
Yes,
45 is where?
madam.
This is 1 to 16.
He's referring to page 45 of the report.
45, your lordship. I am asking the
Okay.
writ appeal. Writ appeal the closure direction, your lordship.
File your affidavit. Sir.
Yes, your lordship. Yes, your lordship.
Please let the affidavit be filed.
So, my lord, I just permit your lordships to file affidavit. What has happened, my lord? There are 3 stages. My lord, I've given an undertaking because I was staying in that premises that if that undertaking, my lord, let's say, my lord, I will lose here, I'll lose before pollution board. What will be the consequence? I can't run a hotel. I
No.
cannot.
See,
Sir,
see, because of the urgency, we are ready to expedite the hearing of the matter.
I'm just saying, Lord, just your lordships, I mean, I will not take much time. The entire exercise was that if it is, I'm not have deemed consent or I don't have deemed consent, what is the judgment of the hand? There's all matters are before lordships. What I'm praying at this stage is an undertaking given to your lordships that the premises be opened where I was staying. Now it is locked, my lord. 38 locked.
This is what we are saying, that
Yes.
as soon as it is possible, 31st of what?
Sir, 30th of August, sir.
38th
One
of
month,
August is
one
nothing.
month is closed down. All rooms are closed down. All rooms are
Rooms were
So may
closed
I just permit,
for
if
years.
your lordships consider under bigger the undertaking, I am undertaking to your lordships. Only premises to be opened or locked.
See, we will have to examine the legality of
Yes.
in fact,
Lord, can kindly see, my lord, my prayer, my undertaking. I would not insist, my lord, because the kindly see my undertaking, beyond undertaking, my lord, even if I lose everywhere, my premises will remain with mine. Not that I can't run a hotel.
no,
Exactly.
because see, you violated the closure order.
Lord, what happened, my lord? I didn't violate. What happened, my lord? I would not violate it. What happened, my lord? When they asked me to stop construction, I came before the Honorable Single Judge. Honorable Single Judge passed an interim order permitting. It is continuing. After disposal of the interim order, without any further notice, they passed this order that close it down means seal it down. Closure
When
is
was the-
different.
When was the order
Sir,
passed
that-
by the London Single Judge?
Yes, my lord.
My lord.
The order of the single judge, Honorable Single Judge, after dismissal,
When was the order passed?
sir, the order of the Honorable Single Judge,
On 19/4/24, your lordship.
19/4/24, he dismissed.
19/4/2004,
24, he dismissed. After the
dismissed.
dismissed. Thereafter, my lord, they have not intimated that they have not closed down, nothing. As your lordship seen that, if
No
you,
question of
No, I knew it, but what
You
I'm saying
knew that your writ petition has been dismissed.
but what I'm humbly submitting before putting a seal, I'm on the seal part, opening part. I'm not on the.
We were also on the seal part.
Yes, sir. So,
So
that is
because-
an industry, my lord. That's an industry. This
This
is
is
my
also
house.
an industry.
This is an industry means it's a residing house.
Hotel is also an
Hotel
industry.
is not industry. Not what I humbly submit. If you also consider with my affidavit and undertaking that the premises.
No
be
question
open-
of undertaking.
Yes.
See, you knew that your
Now,
writ
supposing we not-
application has been dismissed,
Yes, my lord.
and despite that,
But-
you were question of
I'm not having. It's not appropriate for me to insist on a fact which is not said. I'll say, my lord, today I dismiss and my writ appeal is dismissed. What will be the consequence? That I cannot run a hotel. No, my premises will not be taken by the pollution board, not be kept locked. I cannot run a hotel, and in spite of violation, if I do so, there's a punitive action of punishments. There's a punishment. My industry, because it is premises which are residential, which is also residential with a stay. If I do not, look, I am taking to the extreme. I cannot, my premises can't be locked forever, even if I can't run a hotel.
what have you prayed in your
And I prayed, my lord, sir, kindly see, my
no,
lord,
no,
I've
in
given
your interlocutory application?
Yes, sir. Interlocutory application, I prayed that maybe in the prayer, maybe open, and I've given an undertaking. I'll not run the hotel. I'll only open
So
for
that
my stay.
have you challenged the ceiling?
But ceiling comes, it's all consequential, sir.
You could have challenged that even in the writ appeal.
No, it's
That the order is consequential.
the order was never communicated.
Ceiling order, you know.
Can your lordship imagine the ceiling order is, he gives the ceiling order.
Therefore, see, there are two aspects. There are two aspects.
Yes,
We
sir.
were under the impression that soon after the passing of the order of closure,
No, there was a gap.
they had sealed.
There's a gap.
So
No, there's no gap. There's no doubt.
the premises were sealed
Yes.
because despite the order
No.
and despite the dismissal of the writ petition, you were carrying on your.
After the writ was dismissed, after what I'm humbly submitting at this stage, my lord, my prayer is
Your
lordship may consider.
your conduct is not such that we should grant such order.
But I wanted to persuade your lordship that tomorrow I lose the writ, I still
We
have
don't
the
know.
premises.
We don't know.
If I lose the writ appeal also, my premises is not gone to
We
pollution
don't
board.
know what will happen. We
As a-
need to examine
as a lordship,
the law. We need to
As a
examine the
lordship,
facts.
As a lordship.
So whenever all of you file your affidavits,
Yes. Only thing as a
your
lordship. Attention.
your
After-
applications, undertakings, whatever, and the affidavit which you have filed, you just file online and in the
Yes,
registry.
I'll do it. I'll do it. Just after vacation, lordship.
This matter.
My affidavit may be written back, I can file online.
Yes,
In fact, everything we can return, they can file.
Yes, we'll file, sir.
ସବୁ ଫେରେଇ ଦିଅନ୍ତୁ ସେମାନେ ଯୋଉଠି ଯୋଉଟା ଫାଇଲ କରିବାର ଅଛି କରିଦେବେ।
And counsel representing the parties intend to file additional pleadings
ସେଟା ମୁଁ କାଢିଦେବି।
additional pleadings / interlocutory application. Full stop. Let it be done by tomorrow.
Lordship, because lordship may call it now after vacation because
All right. All right.
because it takes time.
As requested, list this matter on. When?
So just after vacation, subject to lordship's can. Maybe
23rd.
22nd, 23rd.
23rd.
So
20.
the same category as your lordship.
Yes.
Another week thereafter, because other matters have been.
But the
posted.
respondent, my lord, is an intervener, is a neighbor, is a.
But I can assist.
But
my
you can
lord.
he's activating the human.
No, but
right.
now he is helping you. Oh.
He's not helping. He's
am to assist you.
He's protecting his.
First he's helping himself, then he can help you.
Yes, yes.
Lordship may call it 22nd is my anxiety, not his.
23rd, let it come on 23rd. If you have any difficulty, we'll let
All
you know.
right.
Sir,
We'll get first 5 cases.
grateful, sir.
Item number 3.
Your Lordship, my grievance is why the script shall not be approved by the opposite party after the verification of the script by the expert member of the SDC Moyurbhanj, finding the script is correct and certifying in the body of the script for the production of the documentary film.
If I may interrupt your Lordship, there are two IAs that he has filed, a rejoinder and a memo. Should it has not been served on us.
The IA number in flag flag A is the no difference. It is the elaborating the matters which I have missed, and then some prayer portion is added.
Huh?
IA number 11696.
He's filed two IAs, your Lordship, for amendment. The list.
Amendment.
Amendment.
Yes.
But you have to serve copy on them.
And he has also
Yes.
filed a
No,
rejoinder
Serve
which
just now.
Already served copy.
no, your Lordship, it's not in the file.
When did you serve?
On
Must be having the receipt, show her.
then I will serve. I have another copy also.
Receipt. No, there's no receipt.
No. Yes.
One more rejoinder.
Memo for documents on this. Yes.
Rejoinder. Have a copy.
Yes, I have.
What is this?
The rejoinder he has filed, and these are
Filed
memo
a
of
copy of it.
documents.
No, she's saying you have not served copies.
Already AG copy have been served, sir.
To whom?
So AG.
If you
Okay.
serve copy on the AG, you will get a receipt.
Yes, I also get the receipt, but now not in my hand.
No, no, we are just asking you to know if they have enough time. If you have served yesterday, they could not have got it.
No. Before 5-10 days, I have filed.
The petitioner is said to have filed interlocutory application /127 12687.
Yes, sir.
The petitioner has filed interlocutory application and interlocutory application.
Who, sir?
Two interlocutory applications and rejoinder to the counter affidavit filed on behalf of the opposite parties. The petitioner in person states that copies of the said pleadings have already been served upon the office of the Advocate General. Stop. He has not been able to demonstrate by showing receipt about service of the said pleadings on the office of the Advocate General. MS Pataklan AGA states that she does not have copies of the said pleadings. Stop. The said pleadings and interlocutory copies of the said pleadings and interlocutory applications have been served upon MS Patnaik in the court. Stop. This matter on after 1 week after 2 weeks after 2 weeks after. So as to enable an AGA to consider the said documents / pleadings. Yes. 30th.
Item number 4.
In this case, my lord, pursuant to Lordship direction dated 25/9/2024, my lord, I am filing counter affidavit for opposite party number 8, my lord, newly implicated party. And I am also solving, my lord.
I will not file any further counter. Adopt the counter filed earlier.
Yes.
Miller. Made, please, Miller. Miller, as late as 1971, Miller, a section 4 notification under the Forest Act was issued by the Revenue Department. For all these years, thereafter nothing happened. Miller. In the meantime, the petitioner is not claiming as of right anything. Miller. The petitioner is a contractor for the construction of 8-lane national highway. There is an mutual agreement in between the Transport Department of Central Transport Department and the state government for support. That is a provision that any materials required under the minor minerals on application, the same will be given for public purposes. In the Odisha Minor Mineral Concession Road. Lord, I applied. And I was permitted a specific quantity to be allotted from one of the quarries which has been operating for all these years, even after the notification under Section 4 of the Forest Act. Then all on a sudden, I was working the query for getting the chips allowed for road work. The Forest Department writes a letter to the Revenue Department that it comes under the proposed forest area under Section 4, and therefore all such operation must stop. Then that order, that Forest Department's order was never communicated to me, but Revenue Officer writes that you stop quarrying operation, and therefore in the urgency that a time-bound program is being halted because of the lack of materials for construction of the road, I came up before your Lordship. Your Lordship issued a notice. Revenue has filed a counter, wherein it is admitted on the basis of the documents, my Lord, that from 71 after Section 4 of the notification, they did nothing, my Lord. My Lord, your Lordship, now I will take, my Lord, to some of the documents, my Lord, filed by the Lord, I think the facts are not disputed, so I will not bother your Lordships with the annexures, my Lord, where I have allotted the work and others, my Lord, except taking your Lordship to certain paragraphs, my Lord. Lord, your Lordship may kindly see that one of the arguments at page 13 of the writ application is paragraph 28, my Lord, towards the last. May I draw your Lordship's kind attention to page 13, my Lord?
Yes.
Lord, let's say page 13. Just
Page 13 of?
Page 13 of the writ application. I will skip through certain arguments, my Lord,
All right.
to save time. Page 13, paragraph 28, last paragraph, my Lord, of that page. Sentence beginning with it may be opposite to state. Has your Lordship got it?
Just a minute. Yes. Page, paragraph?
paragraph 28, page 13, last of the
Yes.
sentence beginning with it may be apposite to state here that since admittedly Anjira BSQ 7 was allotted to the petitions company for the purpose of NHI road work prior to the allegation regarding situated inside reserve forest area. In the interest of the nation, the impugned order vis-a-vis Anjira may be quashed and the petitioner company may be permitted to carry on quarrying operations and transport said road metals in furtherance of agreement under Annex 1. Then, my lord, paragraph 15, my lord.
Paragraph 15 or 3?
Page 15, my lord.
Yes.
Paragraph 31. Sorry, my lord.
Yes.
That further the same area cluster is clearly visible from the national highway and it has been auctioned several times by the revenue department since long time without any objection from the forest department. The first permit at Annex 9 with respect to Anjira Bay School, though has been communicated to DFO Kotak Division on 6th April 2024 through government mail, no objection has been received from the DFO till 2/8/2024. Further, as per the district survey report of Jajpur district, Odisha state, prepared in compliance to MOEF and CC for statutory requirement, BSQ number 7 is shown as one of the Soirat sources. Then we know, I will straightaway take a mercy to there was a state environment impact assessment in respect of the environmental clearance law. And the report is there, begins with page 33, 34, page 34, your lordship may kindly have a glance. Annexure 5. And your lordship got the clause 3, my lord. The proposed query is not coming within the boundary of wildlife sanctuary, national park, area, etc. Then clause 4, the lease area is not coming in DLC list oblique any type of forest land as certified by the mining officer that on certain the proposed lease area is not coming under the DLC list. This is a statutory body, state impact, environment impact assessment authority is a statutory body constituted by environment, forest and climate change under Environment Protection Act. Then we'll on. Your lordship, annexure 11, page 58, your lordship. Has your lordship got?
Yes.
This is when I asked for a blasting permission, the Tahsildar was asked to inquire, and this inquiry report was submitted by the revenue inspector to the Tahsildar Dharmasala. Has your lordship got it? Your lordship will kindly only see that land schedule. During local inquiry, it is found that the below land schedule was declared Anjira Block Stone Quarry number 7 under cluster 1A, recorded tenant, Government of Orissa, Avada Jogya Anavadi. Then the boundary tenants are given. That's the developers in the Then your lordship may kindly look at this.
Yes.
The improved order, that is annexure 18. Has your lordship got it?
Yes. Page.
At page 78,
Page.
annexure 18.
Yes, we are there.
As your order, subject halting of mining activities regarding reference DFO Cuttack's Forest Division letter. Sir, as per the letter of DFO Cuttack, Forest Division Cuttack, you all are hereby directed to halt, stop any kind of mining activity in your respective quarries until further communication at this end. I came up before your lordship stating that. Now the revenue department has filed a counter. সেটা তো 134 লেখা আছে। হ্যাঁ? This order was passed on 13/8 after my lord a joint verification report was up, my lord. Okay, only 2 lines from the joint verification note, page 21. Annexure CY4, my lord. Has your lordship got it? Second paragraph. This is the joint. During the field visit, it is observed that Anjira BSQ number 7.
No, you are at page 19.
Page 21 of the internal page
21 is
of the counter.
correct, part of C4. It's part of annexure C4.
Yes.
All right.
The second paragraph of that report, my lord.
Yes.
During the field visit, it is observed that Anjira BSQ number 7 is an old query of 1990 as per the revenue record. The fresh query permit was issued on 27 March 2004. The fresh permit was issued basing upon the district survey report dated 30/9/2021 approved by the collector DM Jajpur, being the chairman of the committee, having DFO Cuttack, sub-collector Jajpur, and the expert member of District Environment Impact Authority, my lord, as members. The Tahsildar Dharmasala reaffirmed that the Kisam of the said land as per the house settlement is Padmati. Then we have page 22. Has your lordship got?
Yes.
Page 22 top. The date of the final publication of Mauja Anjira is 1/4/2014. As per the regulation, there is no such Mauja named Maulavans. The proposed forest area is Maulavans Forest. The date of the final publication of Mauja Anjira is 1/4/2014. As per the revenue records available in concerned Tahsil, there is no such Mauja revenue village named Maulavans. The draft map of the Maulavans PRF was forwarded to the Tahsildar Dharmasala, FSO of height memo number such and such, Cuttack for approval, but the said map has not been approved by the FSO. Forest settlement officer. Then they gave that notification at page 23/71. that is a 71 notification. Your Lordship, I know, except giving my lord the boundary, your Lordship must say, in exercise of the powers, has your Lordship got it? Internal page 23 of the counter affidavit of opposite party number 1 to 4.
Yes.
Page 23. In exercise of the powers conferred by Section 6 of the Indian Forest Act 1927, the state government do hereby notify that it has been directed to constitute a reserve forest, the land shown in the land situated in the district of Cotton, the limits of which has been demarcated by chains and is cleared with 15 feet by natural boundaries specified below. The block is situated at the east of the expressway running from Toitari Mines to Paradip. Boundaries of the block, north Mukundpur, east Sandhavada, south and south. Then there is no description of the plot numbers also in this notification. It refers to a district survey report dated. The earlier I have shown your Lordship that
the boundaries have been given.
So the entire
boundaries has been given, the area has been given, total area, but specific parcels of the plots has not been given.
The boundary is given, then
Yes.
It is well settled law.
I understand, my lord. I will come to that. Only placing the facts, my lord, which are not disputed. Then, my lord, your Lordship, I have shown to your Lordship that it refers, the draft, my lord, district survey report dated 39/2021. That is that. Whatever.
Yes. Yes.
No, prior to that, my lord, I would like to place that annexure D4, page 31 of that counter, my lord, so that I don't have to travel back. The management has your Lordship order. This is a report dated 6/9/2024 of a joint visit of the page, internal page 31, annexure DY4 of the counter that I was taking your Lordship through.
Yes.
Has your Lordship got it? May I place it?
Yes.
As per the discussion between the collector and GM Jadpur and DFO Cuttack, a team has made a field visit to the concerned area and detailed findings as stated below. Lord, yes, the management map Victor was produced before the team. The Oscar empaneled agency, Spark team identified pillar number 1 referring to the government notification, the position of the reference point and the boundaries in field corresponding to the reference point prepared by was questioned by the Tahsildar and the DDM due to inadequate data available in the notification of the Revenue Department. Except total of the periphery of the forest block, nothing regarding the area of the PRF was mentioned in the notification of the Revenue Department dated 22/7/1971. But as per the approved working plan of the Cuttack Forest Division, the area of the said forest block has been reflected as 114.12 hectares. As pointed out by the DDM Tahsildar, the location of the forest block is not tallied is not tallying. It will be tallying with the reference reflected in the notification. The east of the expressway running from Daitari Mines to Paradip, rather it is located in the west side of the expressway from the Daitari Mines to Paradip. Therefore, the boundary is also wrong. Besides that, the present Anjira village is far away from the base point. Tahsildar Dharmasala also asked for any approved map of the said notification. Tahsildar also expressed about non-availability of any Mujmuri map or approved trace map showing Moldavans proposed reserve forest in Tahsil records. Again, the Hal cadastral map of the Anjira village has not been published by the Map Survey Publication Odisha. So it is difficult to access the exact reference point for DGPS survey of Molavans proposed reserve forest. Spark officials attending the visit couldn't produce the corresponding village sheet of different moja sharing the boundary of the Molavans proposed reserve forest, out of which the cadastral map vector has been prepared and superimposed. Park team was requested to submit the detailed cadastral data before the Tahsildar on 10th September. In the given situation, the approved track map with reference to the revenue department would be helpful for finalization of the boundary of the mountain. So nobody knows the exact area, the boundary description, then plot numbers has not been given. And I will show from the district survey report, Milan, that where in DFO was a party, it was prepared in pursuance of the committee, Milan. So collector was the chairman, that they have earmarked this parcel of land for the purpose of mining of minor minerals, Milan. Now, let me tell you.
No, Mr. Mohanty, the entire controversy is around one point, whether that area falls under the notification under Section 4 of the Indian Forest Act or not. According to you, the boundary which has been given in the notification is not enough to establish that the said area is
and
comes within the notification.
And also I have shown to your lordships that there is no recorded village as Molavans proposed reserve forest.
But the difficulty for the court is,
I understand
that we cannot record a finding.
No, that I understand. I am not saying. I will not be asking your lordships anything which will put your lordships into difficulty or unreasonable. So far as I am concerned with that. I am trying to say that the matter is a day from 71 to 1924, Milord, 54 years running, nothing has happened in pursuance of the 71 notification.
But 71 notification has its own consequence.
But it has consequence. I will come to it. I will take your lordships to the what will be the consequence. That I will take last. I am only telling that the matter is totally fluid and uncertain about the query. Government has been in the government in the revenue department and both forest department has been treating this area as available as a non-forest for non-forest activities all these years.
Yes, still. That Section 4 notification has statutory character.
I will come to that. To what extent that I will come, but I am telling that by that content, it is not that I have gone to them and asked for the query.
In fact, I was just thinking that you can invoke the doctrine of legitimate expectation, that once they provided you, you were under the impression that what they were disclosing to you, everything was correct. This Section 4 notification was not within your knowledge. They had not, and you changed your position because of the assurance given by them in terms of the lease agreement.
I have taken those points, but I am doubtful whether the principle of estoppel will apply as against.
All right, estoppel may not apply. You are right. Legitimate expectation.
That is right.
Legitimate expectation that what the estate had told to you was correct, and you acted accordingly.
I am telling that it was all true. What I am trying to impress upon your lordship is that all through these 54 years, my lord, the forest department, revenue department, everybody has been behaving and doing.
They were violating law.
Doing things, treating these queries as the district survey report is a report, my lord. After the Godavaran's case, it is prepared for each district to mark out the mineral sources, water sources, water bodies, and everything, so that according to that they will proceed, my lord. District survey report also says that these clusters are meant to be given for queries. That only I will place, my lord. Now I am telling, my lord, but everybody say, supposing I am not supposed to have any knowledge about that. I make an application, then they say that this is an old query operating for all these years. This is available. These are the queries available. You choose from which query it will be convenient to you. I give them one option. They say that 60,000 metric tons you can lift.
60,000?
The exact figures I am giving. 30,000?
30,000 cubic
meters.
30,000
cubic meters.
And how much have you extracted?
No.
We have not extracted anything, Lord. After we got it, the election was announced. So it was held up.
They extended the period.
Extended period will end in October. 9/10. Then the blasting permission was not given. Then when the blasting permission was given and I was just preparing myself to leave, then this came in the month of August. So already August and September is gone. I am only telling you now.
Yes, sir.
DSF will come. Can I draw your lordship's indulgence to that forest department counter, my lord, which they filed today, my lord?
Same thing.
Same thing, only thing they are blaming the state government, saying that no action was taken, though they were supposed to have.
Well, at kind of page 9, internal page 9 of today's counter.
They have been negligent. Page 3.
Has your lordship got it? This is 2020, Lord, meeting of the district environment impact assessment authority. Has your lordship got it?
Page 3. Just a minute. So there should have been an affidavit filed by the chief secretary in this case.
My lord, in fact, I have knowledge. I have heard, but I can't produce that document that the revenue department has already written to the forest department that this is a matter of national importance. Please try to sort it out.
No, see, it appears to be a case of interdepartmental conflict also. Conflict also. The forest department is taking plan, the revenue is taking another.
From my knowledge, I can say, Your Lordship, that there is a mechanism available in pursuance of the directive of this honorable court to sort out this problem.
Exactly.
With the government, my lord.
Exactly. In such circumstance,
and in past, many problems has been sorted out in interdepartmental disputes. But it seems now nobody is interested, my lord.
That will have to be invoked.
Well,
see, don't you feel that there is some conflict between the Department of Forest and the Revenue?
Revenue, Steel and Mines and Forest, my lord. Now the three departments are involved because the minor mineral is already transferred to the Steel and Mines department. So three departments are involved, my lord. Revenue, Steel and Mines, and the Forest, my lord.
All the departments have just all the departments have filed their affidavits.
Department Steel and Mines DDM has filed his counter affidavit.
Steel and Mines?
Forest DFO has filed his counter affidavit.
DFO?
My lord.
So DFO represents which department?
Forest department. No, secretary has not filed counter affidavit. Only DFO has filed. If lordship grant, then I will file a counter affidavit for the secretary of the man. Because within a week, my lord, they have implemented on last order, my lord, on 25/9/2024.
Chief Secretary.
My lord.
Let an affidavit be filed by the Chief Secretary. And NHI is a party.
Yes.
No, NHI is not a party.
Yes,
NHI is a party. But notice has not gone. Your Lordship
NHI is a party, my lord. OP5, my lord.
And I can take it by a special messenger.
Amitabh
Das is appearing for the National Highway Authority. I can serve a copy on him. What a decision, my lord. The Honorable Apex Court, where there is an amendment, but I require this environmental clearance, my lord. It came by way of amendment. Then it was challenged, that amendment challenged, Supreme Court told nothing doing. We appealed and no work without another. National Highway Authority then approached the train that it is for the public purpose. Then the Supreme Court told that whatever has been done. The ongoing projects you give a list, will allow. And they allowed it. And this one I have got.
But that again, Supreme Court. Passing such an order.
That's true, Miller. Well, I am telling that public purpose has a dominant role to play in this matter, Miller.
No, Mr. Monti, it is difficult for us to do that for the reason that Section 4(1) notification is not in dispute.
That's right, Miller.
So what is in dispute is that can be seen by all of us.
The department has the authority under the Forest Act, my lord, to exclude person even for a temporary period.
What is that? Where is that?
That is then Forest Act. The Forest Act Section 4 notification is there, it gives, Lord. Then the Section 5 says that bar of accrual of forest time. What I mean by this is that no new right will be created in the proposed area and the existing rights will continue until all claims are settled. And it is divested from there may be private lands also. There may be cultivation inside the proposed forest lands also. There may be a government contract also. And save and accept the accrual of right by succession and the agreement. All other rights, no further right has to be created under Section 5. May I place
Yes.
Section 5? After the issue of a notification under Section 4, no right shall be acquired in or over the land comprised in such notification except by succession or under a grant or contract in writing made or entered into by or on behalf of the government. So, exception they can exercise, my lord. Then your lordship will see that forest officers, my lord, paragraph, section 11. Has your lordship got it?
Yes.
Section 11. Power to acquire land over which right is claimed. In the case of a claim to a right in or over any land other than a right of way or right of pasture or a right of produce or a water course, the forest settlement officer shall pass an order admitting or rejecting the same in whole or part. If such claim is admitted in whole or in part, the forester shall either exclude such land from the limits of the proposed forest or come to an agreement with the owner thereof for the surrender of his rights, proceed to acquire such land in the manner provided by the undertaking, land acquisition. Then order, then also even after the record of rights is reserved, it is declared reserve forest under Section 20. Here, let's look at Section 23, madam. Even after the notification under Section 20, madam. May I place Section
Yes,
20?
please. Please, miss. Please, please.
So, what I was stating now, even the forest settlement officer has a power to exclude some person. Then your lordship sees Section 23. Section 20 is the final notification.
Yes.
No right of any description shall be acquired in or over a reserve forest except by succession or under a grant or contract in writing. So the government has always, here my humble submission before your lordship is that I make them an offer. They fix the consideration money. I pay the consideration money. They accept the offer, alert me, and give me permission to lift me down. That is a concluded contract with the government. And this right can be protected, even if it is notified under Section 4. Am I clear, Miss? So,
let us see.
Huh?
We are issuing notice.
No, notice.
Notice to NHA. NHA.
I may be permitted to, my friend may be permitted to serve a copy on the.
Serve a copy. Come on Monday. Tell whether he has accepted the notice or not.
Yes.
If he accepts notice, then we will pass order. We may direct the chief secretary to file an affidavit because of the conflicting.
Monday, I was thinking that I will not stay, but anyway, I will come.
No, you don't want to come. All right.
No, Monday I will come.
Mr. Pradhan is there.
No, I have already given an accommodation memo.
Who is the junior most in your office?
In fact, to be very frank with your lordship, for last 25 years
You have not
or so,
kept any.
I am not maintaining an office.
All right.
Because I wanted to get rid of that problem of maintaining an office, and then for the clients, instead of asking the office of the case every day ringing me up and telling that.
And,
that's happened.
and yes, senior rocket can afford that.
So I stopped filing. Only
All right, anyone.
lady is there because she is computer savvy and I don't know anything of it.
All right. Anyone, let anyone be.
No, I will be there on Monday. It's no problem.
All right. Place this matter on Monday. In the meanwhile, let a copy of the writ application be served upon and counsel who represents opposite party number.
6. 5, no? 6.
What? 5, 6, what?
Generally, in this
Six.
generally in this court. Oh, stop. Next. After having perused the pleadings available on record, including the counter affidavits which have been filed on behalf of the state respondents, we are of the prima facie view that the issue involved in the legal issue involved, legal and factual issues involved in the present writ application are required to be addressed based on the stand which may be taken on behalf of, taken by 3 different departments of the state of Odisha, namely, tell the department names of it.
Mining department, forest department, and forest
The revenue.
department.
Stop. Next. We may consider directing the Chief Secretary Odisha himself to file a consolidated counter affidavit dealing with all the aspects which have emerged in this case. Just tell them.
My lord,
Forest Department counter affidavit, have you e-filed it?
he filed it.
When?
110. 1-10.
Department has not filed.
DF has filed.
Oh,
You
sorry. Here.
Yeah, may I say one thing? No? Let him also take the instruction that whether the chief secretary should intervene in the matter to sort out the problem because it involves public purpose.
It will be open for the Chief Secretary Odisha to intervene in the matter which also involves public purpose for sorting out the problem without violating any statutory provisions.
My lord, your lordship may not write that, otherwise with the bureaucracy's angle, they would say, they will not go deep into 4 and 5, they will say that forest notification will not touch it.
We'll see.
My lord, your lordship, I know, my lord, your lordship has been pleased to give that there should be no adjournment in all matters.
Yes, still.
In fact, last 10 days I am not well, suffering from viral fever. My lord, may I only pray for reopening week, my lord. In fact, because of that, my application amendment I have filed, that was filed today because of my bad health also. I have got the number. Because earlier amendment petition, since there was some anomaly, your
Counsel
lord.
appearing on behalf of the petitioner has appeared and has submitted that he had been indisposed for last 10 days and he is not in a position to effectively make his submissions today. Stop. Considering the exceptional circumstance, list this matter on next week.
I was praying for reopening, my lord.
Yes, reopening.
Item number 6. Item 6.
Please, Your Lordship. My lord, I have received one letter from the HPCL that they need some more time to settle the matter. And my learned friend has now received a WhatsApp message.
Lord, I have been consistently following up with them because the Lordship has been most indulgent in granting us time, my Lord. Post Navratras, they are going to be, my Lord, setting up a committee and negotiations are going to be taken at full speed ahead. Therefore, I request, my Lord, any short adjournment, my Lord, subject to your Lordship board and kind convenience, my Lord, towards the end of the first week, as your Lordship please.
On behalf of the petitioner, list this matter on 7/11/2020.
7th November, very well.
Since it has been submitted, that the parties to the dispute are in the process of an amicable resolution.
My Lord. Deeply grateful, my Lord. Deeply obliged.
Item number 7.
My lord, I'm sorry, my lord. This I pray
Same.
for reopening.
Same order.
I'm grateful, my lord. I'm grateful, my lord.
Item number 8.
Item number 8, I pray for 1 week time for filing the rejoinder. Lord, I received the counter, gone through the record, but some more time will require.
When did you receive the counter
Receipt-
affidavit?
The receipt last week is on 5/9 they have filed counter, but subsequent.
Few weeks ago, I was praising Odisha High Court Bar that even in the old matters,
Your Lordship,
they are present and they are ready to argue.
I have received the counter, but gone through the counter, but there is a two difference policy. I gone through the record. One more chance I will give, and I'll after reopening, Lordship. Before vacation, I will file and copy will be served. Other side.
So when was the counter served on you?
The 5th of September.
This is item number 7. 8. 8 render activity is there. You not yet received. You have not. When did you receive?
After 5/9, they
On
filed.
6th we filed it, Your Lordship.
6/9 you filed counter affidavit.
Lordship.
Why? Notice was issued late.
Notices were issued to us in the year 2022, Your Lordship.
And counsel appearing on behalf of the petitioner seeks further adjournment to file rejoinder to the counter affidavit also by way of last and 2 weeks time is allowed for the said purpose. This matter on post holidays. Yes.
Public.
Item 9.
Yes.
Yes, this is the matter with regard to that compulsory retirement. In the last occasion, your Lordship wanted a decision of Justice Loda. And it is from Patna, but I have verified it is not from Patna, but there is a decision of Madhya Pradesh High Court.
Yes.
That has gone. Justice Loda is the judgment delivered by Justice Loda.
Yes, this was the order which I was.
Yes. So
looking.
there, Miller, the order of compulsory retirement, the very first classitum, the order cannot be go into adequacy or sufficiency of the materials which the order is based. That's what what your lordship is intended to tell me that day. See.
We just.
Yes. First review case, where in the very first review, he has been compulsory retired, then he challenged, then the court held that adequacy cannot be gone. That's what it has been held. In my case, this is the second review, So therefore, I'm relying upon the 85 Supreme Court of 2011, which I have paragraph 85, which I have already shown that there should be fresh material between the two reviews. That paragraph 85 of 2011 Supreme Court, which the other day I have shown. 2011, 10 I have given that book.
Yes.
So this para 85 minute the other day I have read out where the fresh material is required and it should not be a review of earlier decision. 2011 10 SEC.
Yes.
At page 44 is paragraph 85. I have given that decision to your lordship.
Yes.
And records, with the government, that government council, they will produce, verify that records. All these materials which they have relied upon, they are prior to 2006 when my first review was held and I was continued in service thereafter. And 2009 only I was compulsory retired. So there is no material between 2006 to 2009. That's my case only. And this is a small for your lordship what I have stated before.
That is there. Short dates.
Short date, and this is note.
Please give.
Yes, I have given.
No, that decision from Patna was on a different point.
Millard?
That decision from Patna, which I was referring to, I must have missed the context.
And 2001 Millard.
This one. In fact, this is also from Patna. The issue was that decision was taken by the full court.
Yeah.
The Supreme Court remarked that full court decisions should not be interfered so lightly by on judicial side, because those decisions are taken. This has never been the view earlier. That was the view taken in that case.
There is another decision. Maybe just see your lordship. This is from High Court Judicature Patna, 2014. Just see.
2004, maybe 2014.
2012 also there is a judgment from Patna High Court. It's not Registrar General High Court of Patna versus Gajendra Prasad and others.
What is that?
Plus, paragraph 23.
The author's name?
Maybe that.
Author of the judgment?
Author of the judgment is Justice D.K. Jain and Justice Hamidar Dagan.
And that one?
We made Justice E. Sathasiram, Chief Justice, Justice Ranjan Gogoi.
It is because of my poor memory that all of you are suffering.
These are the
Paragraph 23, your lordship may look at. Same view, your lordship telling.
Casual recording of it.
Yes, paragraph 23.
Yes, ma'am.
Yes. Nobody. I've forgotten. Sorry. Principle, I remember.
Plus another judgment I rely upon of the Supreme Court 2011. Of the same language is almost the same. Paragraph 192, 208 and 218 minutes. Long judgment. Hundred and 92, 208 and 218 minutes. These three paragraphs.
Two zero eight para.
Paragraph 208 and 218. Three paragraphs.
This Patna judgment has referred to that also.
Yes, they have also referred same, but specific paragraphs I wanted to show you, Lordship. In somewhere they've also discovered the doctrine of pleasure also, my Lords. Same judgment.
Same judgment.
Yes, yes. I have referred to different paragraphs only.
Yes. You have relied on this, Samdev Singh. This is Sardar Devan.
I have given.
You have given. That was a different case.
Yes.
That was extension
Yes.
after
Yes.
58 years.
Not only, I have
That
shown.
was, yes,
But
but that is very relevant. The consideration is very relevant.
Even though the same decision we are relying. Same decision we are relying. I am relying 85. They are relying para
192 and others.
192 million. I am not on the question that court cannot exercise the power after 50 years. I am not questioning that.
Your submission is as to what should be the consideration.
Yes, because between Miller 150 there is a review and he has crossed it successfully.
All right. So let us see the rule. There are 3 stages.
Will not. 50, 55 feet.
And there is a proviso.
The proviso, yes. After 50 every year.
The proviso,
yes.
The proviso is independent of 1, 2, and 3.
Yeah.
No, that proviso is provided to 2, subsection 2.
Yes, but just a minute. If I remember correctly, which
Yes.
rule 50?
Rule 44, my lords.
44,
Rule 44.
Yes.
Yes.
Here it is rule 44.
proviso, Millard, the rule 2 proviso.
Just a minute, just a minute. This proviso is independent of the power which can be exercised by invoking subsection subrule 2.
Yes. Millard,
This
what
is an independent power.
No, independent power. But once there is a Millard 44-2 exercise, Millard, if Millard, this
See,
cannot.
No, mister, you will have to read this rule like this.
Yes, Millard.
Rule 1
Yes.
confers power
Yes.
to retire compulsorily.
Yes.
Rule 2 provides that at least 3 times after 50 years, there shall be review.
Yes.
And the proviso says that the rule 2 will not in any manner control
Yes.
the power of the governor to compulsory retire an officer under rule 1.
Millard, that is true. There, Millard, I'm not disputing that.
That power is independent of review.
Millard, that is true. Nothing in this, Millard, your lordship, what your lordship is saying, provided that nothing in subrule 2 shall be construed in public interest as preventing the governor to retire after 50 years. So, Millard, what happens here? At the age of 50 review, Millard, the fact is that is a review. And review he successfully crossed. Then at the age of 52, this Millard, the proviso has come. So, Millard, if your lordship will give a meaning to proviso, that it can be, the same materials can be looked into. That means review of review.
52 is independent power. Even if there is anything, there is nothing against you. 52 is inherent. 50.
No, Millard, it's inherent.
Millard, proviso.
Even
proviso.
No,
44th proviso.
Yes, Millard.
That gives the inherent power.
No, that Millard, that Millard, I do not question Millard that power, because even this 2011 Supreme Court has stated Article 235 also gives a power that for the interest of the public.
All right. Where is the provision for voluntary retirement? Where is the provision for voluntary retirement?
Voluntary retirement. That I have not verified.
All right. So I'm referring to voluntary retirement for the reason
Yes.
that there is employer-employee relationship.
Yes.
That can be severed by, if you want, you may resign.
Yes.
If you want, you may take voluntary retirement. You have a right to seek voluntary retirement after notice. Similarly, after you attain a particular age, even if there is nothing against you, the kind of handshake, all right, you serve the institution, we don't need you anymore.
Millard.
But for that, the subrule 2, yes.
No, Miller, your lordship, Miller, that is how that they have said only on one ground it can be challenged, either arbitrary or malafide. So once arbitrary comes.
That will, you are right.
Yes. So once arbitrary comes,
Yes.
then Miller, the EP RAPA, Miller, that 85 paragraph comes, then Miller, the Tata Cellular.
You are right.
So that is how Miller, that is only that is the rider.
That.
And in that rider, Miller, I am putting in this.
All right.
This 85. Miller, that your
will.
lordship, paragraph 85, your lordship.
We will consider.
And there was a Orissa High Court division bench. That's that which I have given at the first instance. They have said that there should be new material. I have given this, Miller, to your lordship.
Yes, it is there.
Yes. So that your lordship said that this is what, if your lordship, that is that paragraphs I have given, 25, 27, 24, 25, 26, 28. Para 8 and 15 is the Miller fact. That's the 50-55, not proviso. Proviso was not considered. This is a 50-55. Proviso was not considered. And in our case, Miller, DPI was exonerated, and that was not placed before the committee. That's something I have avoided it.
On behalf of the commissioner and after some of the AGA for?
Yes.
You have represented whom?
Yes, I represented the all the opposite petitioners.
The opposite parties. Let's see. I think for this matter for judgment on. Of November.
Very sorry. Records, if you want the original records. Okay.
Records you can not required.
Item number 10.
I have soft copy on the 25.
Yes, my lordship, I have received that copy. I have prepared my argument on merit. I want to submit it before this court. Lordship, the cause of dispute in this matter.
Mr. Modi.
Sir, my lord.
Can we suggest that we will hear you, we will hear your oral argument also, but can you give us your written notes point wise so that it may be easy? In fact, it be well versed with your case, but the lawyers have that expertise to place their case brief. So if you can, you just give your written notes of argument and we will hear your oral argument also.
So I will deliver.
That will shorten the time.
Okay, sir. My lord, I will give my oral argument today and also I will submit my written arguments.
Have you given the oral argument? Written argument?
I have not given.
First give that and then make your submission with reference to the points. Are we clear?
My lord, I wanted to give the oral argument today so that I can give my written argument.
You should what in your case we are suggesting this, that you give your written notes of argument.
Yes, sir.
And then point wise, so that you may say that I have mentioned this in my written note argument, and we can conclude hearing more expeditiously.
Yes,
So today you give?
Today.
Next Thursday, we'll hear it.
Can you do it today or by day after tomorrow you'll give the written argument?
I'll need some time, my lord. I'll need some time to give my.
Your written argument should not be voluminous.
No. It is, I can, within 5 minutes, I can also give my oral argument today, my lord.
No, we are talking of the written argument.
Yes, written
point
argument.
with reference to documents or annexures, if you give it, it will be convenient. So by what date can you give it? By next week or you want more time?
We want some more time, ma'am.
Then after vacation?
Yes, ma'am.
Which time?
By 23rd is all right, 23rd October?
Yes.
Petitioner is appearing in person. So, as requested by the court, he has agreed to submit his written notes of argument by 23rd of
October.
23/10/2024, so that it may be convenient for this court to effectively appreciate the submissions which.
There is another request, my lord.
Order stated, please, we'll hear you, one moment.
Orally on the state. First of all, does this matter on? Which date do you want?
After 23rd, any date. My lord, I have a small request. Based on my written argument, the matter may kindly be decided. We need not give any more oral arguments or anything like that.
If on the next day, if you say that you don't need any, you are not required to make any oral submission, we will close it.
So we are keeping it to 23rd. By that date, we're keeping.
23rd or after.
He has to serve copy on Mr. Sahu. Next day.
No, 23rd or after.
So we can fix it on 30th. 30th?
30th, not 30th. 7th November. 7th November, Mr. Modi.
Mr. Modi, by on 7th November, it will listed. You submit your written argument by 23rd or 24th? 24th. You submit it by 24th after serving copy on the learned counsel for the other side. And on 7th, if you say that you don't want to make any other submission, we'll close it and decide on basis of your argument. Or if you want, you can make your oral argument on that day.
All right. Oh, you wanted to say something?
Anything else?
No, it's all. That's all.
Would you please serve a copy on the other side when
Yes.
Item number 11.
Number 11, my lords, I'm appearing for opposite. Two of the opposite parties, other opposite parties have not appeared. Some of them have died also. Last date is a old matter. Last date I've taken time to get instruction from the council who has engaged me. Well, sir, last night, my lords, I got some repetition copy and all these things. It's a matter relating to 48 estate abolition, 48, my lords, Property Transfer and Estate Abolition Act, determination of intermediary interest, my lords. I pray, my lords, some time so that I can prepare a note and can give it before my lords. And before my lords submitting, my lords, my submission in oral.
No, that was for him, Mr. Modi, no.
No. That is sorry, my lords. Is that, my lords? It is a matter, my lords, very importance to my lords. So 1948, then 1951, then 64, 65. My lords, OA settlement, my lords, that it relates to my lords 3 generations. And the fact remains, who has engaged me, some of them are died. My lords, his residential abode is there. Well, the intermediary, the Jamidari abolition is there, but subsequent orders are under challenge. So it requires some study, my lords. That is what is my humble contention. It requires my study, my lords. I've taken time. I know that it is an old matter. I'm conscious of the position. Apology, my lords. I request for time.
What is is there any shortcut?
Shortcut, my lords. I tried, my lords, but it may not be possible. Well, I'm trying, my lords. I find out if it will be so that I can, my lords, bring it within one sentence. It can be, my lords. I'll try my level best.
Yes.
I'm ready. I'm ready. If my learned seniors wants to seek time.
It is great.
You've scared us, but she is standing strong.
They have possessed the document. Yesterday night, because the fact remains, my lord, the council who engaged me suffered from brain injury. And that
Brain
is,
injury.
that is what is the problem, my lord. So I couldn't collect all these informations. And with much difficulty,
Yes,
I
madam, that is, we cannot decline adjournments.
Lordship, may
Well, I will go through. I will see that if there is a shortcut my lord's process, I will appraise before my lords. I will place it before my lords.
All right. As requested on behalf of the opposite party, opposite parties.
My lords, not all opposite parties. Some of the opposite parties died. Opposite party number. I am for opposite party number.
As requested by Mr. Mohapatra and council, list this matter. When?
Well, so after vacation, any date after vacation, well, during vacation, I'll prepare it, my lords.
Then why don't you appear for the
Well, so
DPS?
they have not engaged me. Well, fact remains, my lords, they are all in third generation.
Oh. 24th.
I am for opposite party number 4, 5, 6, 9, and 12.
Can't you represent the other the legal heirs of the persons who died?
Lordship, we already have filed IA for substitution. Lordship had, instead of deciding those IAs, Lordship had straight away seen the impugned order and decided that prima facie we need to decide this before any other party expires.
No, that's why we are asking him that if he is willing to appear
Well,
for
may I
the
submit one sentence, my lords? They all some of the opposite parties, my lord, they are all relations. Means they are all third generation, of course, brothers and sisters related in this way. I am trying, my lords, to get a Baklatnama from them so that it will shortcut the process, my lords, without taking time. We can set it out. So for other purchasers, there are other purchasers. The purchasers, my lords, I cannot appeal. So far, these substantial representation will be there.
We are one of the purchasers.
But their right will depend on
upon
the result of this case.
Yeah, otherwise also it is a substantial representation because I am representing my lords. Well, so far 2 brothers are concerned, other 3, one of them died, 2 of them died, and that's to come. But there will be a substantial representation.
All right. 24th.
My lords.
24th of October.
My lords.
Item number 12.
Item 12, my lord. This writ application had been dismissed by this honorable court. On the ground, my lords, my case is I was allotted a plot for building up a hotel. Now, because my lords, there is a stormwater drain which has to pass my plot between 2 higher plots. We approached the PE department to make the necessary stormwater drain. They did not do so, and so it was kept pending. Now, because of that, I had filed a writ application that because of the inaction of the PE department, we are unable to, my lords, execute the hotel project. So there was a determination of lease in the meantime, and we approached this honorable court. This honorable court said, no, you are, this writ is liable to be dismissed. We find no cogent reasons and dismiss the writ application accordingly. Later on, we came to find, my lords, that all similarly placed hotels who have got necessary permission from various departments were given, the government gave them further extension of 3 years from the date on which they get the necessary permissions and to execute performance guarantees so that they will complete the project within 3 years and complete the project. So thereafter we filed the writ application annexing that document. We filed the review application annexing this documents. Being satisfied, this honorable court allowed the review application, restored the writ application to file, and further, my lords, by order dated 16/12/22 in the review, my lords. Review is connected.
Yes.
My lords, this in our considered view, the second paragraph, In the considered view of this court, in the light of the pleadings in the review petition, the court is satisfied that there are sufficient grounds for review of the order dated 14 December 2021 passed by this court in WPC number 24283 of 2012. The said order is hereby reviewed and recalled, and WPC number 24283 of 2012 is restored to file of the roster bench of this court, where it will be listed for further hearing on 20th February 23. Thereafter, in the writ application, if your lordship sees, order number 6, that is order same date order. Order number 6 says 16/22 order, my lords. The writ application is restored. Wide order passed today in review petition number 37 of 22. List on 20th February 23 before the roster bench. The interim order passed earlier shall continue till the next date. The pleadings in the review petition can be relied upon by the parties in the present writ application as well. In the review case,
that was revealed in the comfortability.
Yes.
my lords, before the origin, when we had filed the original writ application, where we had alleged discrimination, they never revealed that similarly placed hotels had been given such relief. But in the counter in the review application, they revealed this. So it is also recorded. In the order in the review petition, 16/12/22 order, same order, my lords, the first paragraph has perused the affidavit filed by the state today, where it is simply stated in para 4 that the hotel cited by the petitioners, in respect of which performance bank guarantees had been called for, are not similarly circumstanced with the petitioner, in as much as the hotels like the petitioners one is coming under category of hotels. Unlike the petitioners one is coming under the category of hotels. This does not explain why the petitioner's case is different from those hotels from whom performance bank guarantees have been sought. We squarely come within the definition of hotel, my lords, the lease deed itself, which has been. Now your lordships may kindly see the review petition itself. Annexure 12.
Whether any counter affidavit was filed in the review application?
In the review application.
Counter affidavit was filed?
Yes, yes. And in the review application, when they agreed, they could not dispute this. At Annexure 12, they have given, if your lordship sees 173 of the writ application, my lords, of the review application, that is Annexure 12, they have given, my lords, they have taken a conscious decision, my lords, proceeding, lordship, I'm just reading it out. Proceedings of meeting on the matter of non-utilization of government land allotted by G and PG Department for development of hotel projects in Bhubaneswar on 22 at 12:45 INCS at Lok Sabha Bhavan under the chairmanship of the Chief Secretary. Then they give the names of the various hotels: Trident, CJS, Cabana, Swami Resorts, ITC. During the meeting, they were asked to submit the plan for development of the allotted land parcel along with timelines for development of the same. Subsequently, no follow-up could be taken because of COVID-19 pandemic. These companies have been withholding premium land in Bhubaneswar for long years, ranging from 13 to 34 years, without developing, augmenting the land existing property, and in the process preventing genuine and interested developers, hoteliers, from developing hotel projects on the allotted land parcels. A brief status of each case was presented. Thereafter, my lords, at page 174, and then they say that they extended everyone, asked them to give performance guarantee, some 50 from 55 crores, some 68 crores, depending on the size of the plot.
18 of the reply.
Page 18 of the reply affidavit. They admit this fact. That in response to the averments made in paragraph 3.12 of the review petition, it is further submitted that the format of performance bank guarantee were communicated to the director of Cabana Hotel Management, company secretary GJS Hotel, director Hotel Swami Resorts, and to ITC respectively to submit performance bank guarantee for better utilization of the leasehold land. The gist of the action to be taken by
So you are claiming parity, that's all.
I claim parity. That's all.
So far as Cabinet and many others, Lords, they also failed. Even though particular granted, they filed writ application. Lordship have been pleased to direct them to file a representation before the authorities pending disposal writ application and giving liberty to Lords move so that they will take a decision, Lords. In this case also, they may Lords pending disposal, let them make an application to the GA department, giving all the, because in that Lords order at page paragraph 1 of the review order, we have not admitted that is similar because the language clearly states Lords, affidavit filed with the state today where it is simply stated para that hotels cited by the petition in respect of which performance guarantee had been covered for are not similarly circumstanced. We have not admitted. So let them make an application. Let us consider it. If they fail it, then Lords, you can take it the matter on merit. After the holidays, let them make an application within a week and we will consider it with all materials they are now citing. Lords.
Give me that 3-year extension with the.
And if they are not interested, then Lords, you may take it up on merit. So saying that we get 2,000 leads. If they are not interested to make an application, Lords may take it out on merit. Lords.
No, my lords, my case is that you have not determined anyone's lease. You have extended everyone's lease by asking them to execute performance guarantee. I am a similarly situated person. So you should have same my lord's treatment should be meted out to me, and I should be given that 3 years extension. I will give a performance guarantee.
No, the court will not direct for that. The court may direct them to consider.
That's good.
Yes.
Even if we finally decide the matter in your favor, we shall be directing them to consider in the light of that.
In the light of the treatment given to the other hotels.
In the light of the stand which you have taken, that similar treatment has been given to the others. That is the maximum which the court may do.
And as my Lord Senior said, Lords, his lease has been determined. So far, others' case, there was no determination. They were not refused extension. So there is also a distinction.
Determination, again, the writ application is restored to file and interim order has been.
Obviously, that order is under determination order under Annexure 1 is under challenge, Lords.
No.
Yes.
That's all. Yes, my lords. My treatment should be at par with the other hotels.
Oh, whether that aspect has been considered by them or not.
My lords, I'll make a fresh application again.
Therefore, when you are saying, see, your writ application was dismissed.
Yes, ma'am.
You file a review application. That's similar in similar circumstances, others have been allowed to continue.
Yes, ma'am.
That review application has been allowed and the writ petition is there before us. Your claim that you are similarly situated, whether that has ever been addressed by them or not.
Correct. My lords, that has never been addressed.
Then you'll have to approach them.
We never knew that they have given out.
No, now you know. Now you know.
Yes, my lords, I'll go. Your lordships may say I'll make an application and let them consider my case.
You said that.
No. Your lordships may, my lords, make an observation that we will make an application and they will consider it in the light of the proceedings at Annexure 12, that is 22-121.
We are disposing it off, we'll dictate the order.
Well, another thing that I will just point out before your lordships, they had taken a specific stand that we are not hotels, which the court, my lords, discarded, and accordingly the review application was filed. In fact, our lease is for a hotel loan.
And 90 years auction.
And 19 years auction.
Auction.
By auction, we have taken the lease. It's not that it's a backdoor entry or something. It was not a grant or a large obliged.
Place admission item number 14.
That might be also issue notice because the other side comes in. We have some copies, but you utilize that copy also.
It's that case of drugs inspector. The selection process was challenged by one unsuccessful candidate having participated in the selection. But he remembers that one.
No, please back. Before asking them to pick, we have. No, we have dictated the order. Thereafter, we said some copy and try to serve copy.
Notice.
Yes.
Notice.
It's a returnable date so that we can.
Yes, returnable date is always fixed.
6 weeks.
6 weeks.
Returnable
1
date.
week.
1 week.
Can we take notice by 3 post? Can it be tally?
No, one person. We can take it by special messenger also.
Only one person. Special messenger.
All right. Where is he?
He's from Bhubaneswar.
He is from Bhubaneswar, yes. Nagarkot, that's
Special
20-30 kilometers.
Take notice by special messenger. So we can come back anytime convenient to.
You see? He's not working anywhere. Does
Is he employed in any office?
No, he is unsuccessful candidate.
In addition, special messenger. 4 weeks.
Both ways.
Both ways. Great.
7 in there.
Ah.
Item 15.
Item 15 may be tagged with 48. Item 48, it may be tagged.
Item 14?
You want item 15 to be tagged with 48 or 48 to be tagged with 15?
No, item 15 to be tagged with item 14.
Not 48 to be tagged with 15.
No, my item 15 to be tagged with item 48.
Okay. All right. What is in 48?
Where does that matter?
Extension, Lordship, remember extension 148 capital A. COVID 168A, the Lordship.
Yes. 15 and 48.
Yes.
Both of them will come when? Whether in this case any order has been passed?
Yes, my lord. Your lordship has given protection to all the petitioners.
In 15 also?
15 years of face admission.
15
No interim order has been passed in 15. Yesterday we had mentioned it.
So he does not interim order, he is saying taken up with 48.
In fact, his friend would be appearing on online. So yesterday somebody from Hyderabad had appeared online. His friend.
All right. Interim orders?
If he's blood paid, then if he's paid for that,
all right.
That is enclosed. He has enclosed the all these similar matter studying from running page 15, page 48 and 49.
15 and 40. No. 15 and 48. When are these matters coming?
Today it was on the board. Item 40.
Oh, we will take up then. Please. All right. You are right. We are sorry.
Item 16.
May it please, Milots. Milots, I beg to appear on virtual mode, Milots. Milots, am I audible, Milots?
Yes.
Milots will have your lordship's order number 2 dated 24th of September 2020.
Yes.
Millards will recollect, this is that matter where I was stuck between the devil and the deep sea, Millards, where it is relating to that sand quarry where I was unable to transport. On one hand, the mining officer says that there is an earlier judgment of your lordships which says you can't transport from 7 a.m. to 9 p.m. And then the Gram Panchayat says that you can transport only from 4 a.m. to 4 p.m. So, Millards, this is that matter. Your lordships directed me to make the application more comprehensive in order to decide the matter together. I have filed an amendment application, Millards, to that extent. If your lordship will consider allowing that amendment, Millards, and then your lordships can consider issuing notice. That amendment application, Millards, I have done, your lordships directed me to make Millards the Revenue and Disaster Management Department a party and the Panchayat Raj Department a party. I have added them as opposite party number 4 and 5. And also, Millards, I have made a prayer where your lordships will recollect there was a order. If your lordships will kindly see what the mining officer says, that he relies on the judgment of your lordships and says that 7 to 9 p.m. you are not permitted. But Millards, I pointed out to your lordships that it was in fact only the submission of the learned advocate general, where at para 22, however, the Honorable High Court, this Honorable Court, directed the state to take necessary steps in regard to the traffic management from 7 a.m. to 9 p.m. So, Millards, that to address all these things, your lordships directed me to make them a party, the Revenue and Disaster Department a party and the Panchayat Raj Department a party. I have made that and also made the application more comprehensive. So, your lordship may consider allowing that amendment application, which I have filed, Millards.
Sub-punch is a party, not required.
No, Millards, Gram Panchayat itself is a party, Millards.
All right.
The Gram Panchayat itself is a party, Millards. Is OP number 3, Millards. And flag IA is flag A is the IA for amendment, Millards. Okay.
IA 13272 of 2024.
Please, Millards. Please, Millards.
Filed for amendment of the writ application to bring on record.
Millards, the schedule is at page 4 of that IA.
To add the state of Odisha. On 327, this IA has been filed for amendment of the writ application. In terms of the proposed amendment, which is contained in the schedule of the petition, which is reproduced, which is extracted below. Full stop. The Mr. P.P. Mahanti, learned additional government advocate, has no objection to this said prayer. The IA for amendment is accordingly allowed. The IA is disposed of. Related writ petition we filed in
2 days, Millards. In 2 days, we'll file. By Monday, we'll file.
By 7/10/2024. After serving copy on the Learned State Council, this is the case of and the learned amicus curiae list the case on it's the case on 7/11/2024 for fresh admission.
Subject to your lordship's consideration, my lease period will also expire soon. If your lordship will consider some date in October, Millards.
Okay, list the case on 30th/10/2024 for fresh admission. Yes.
Very good. I'm so grateful. Obliged.
Item 17.
May I please, your lordship? May I permit it to BC, your lordship?
Yes.
Yeah, item 17 that it relates to blocking of portal registrations. Your lordships had to Learned State Council to take instruction, my lord, whether the compliance of regulation 23 of the blocking of portal registration guideline, your lordships.
I think that we just asked to mistake. You asked?
What had we directed?
Your Lordship, page 91 is the guideline to block the portal registration. My portal was blocked because the
No, but there was no order.
But
No, here is the case, Lordship, the director will take instruction. Here is the case where he failed to give the additional preference security within time. So his bid was cancelled, and thereafter, his portal has been blocked. Now he has confined his writ application to only blocking of the portal, saying that because it wasn't the case, you also wanted me to show from the records whether the opportunity of showing cause was given to him or not. Lordship may kindly first come to Annex 3 of the writ application at page
111.
Annex 3. Page 111, again. Sorry. 15/7/2024. Here the letter of intent was given to him, given to her, and she was called upon to give the purpose guarantee by 22nd. Page 111, Annex 3.
Action deemed proper as per codal procedure will be initiated.
Again, there we have given that if you fail to it, as per codal procedure, provision will be initiated. That is the last paragraph. And thereafter, see letter under Annex 4, page 113. 113, inviting reference to subject of such and such, you have failed to do, and so last paragraph, in view of the above facts, you are called upon to explain.
So just a minute.
Yes.
So you said that the action deemed proper as per the codal procedure will be initiated.
Yes.
So what is the as per codal procedure?
That is not my friend was showing to Lordship, page 91. Sorry, so page 91, blocking of portal registration.
Page 91.
Yes. Clause 23.1. If the registration is not relevant for us, relevant is 23.3.
Just a minute.
23.3 minutes. The officer inviting tender shall make due inquiry and issue so-called notice to the concerned contractor, who in turn shall furnish his reply, if any, within a fortnight from the date of issue of such so-called notice. Thereafter, the officer inviting tender required to issue an intimation to the defaulting bidder about his uncertain reply and recommend to the chief manager for blocking of the portal.
That has not been done?
Yes, we have not. Portal has been blocked by the authority. We called upon her to submit a reply by 8/8. She submitted a reply by 30th of July 2023, saying that accept my APS, and she therefore my health grounds I could not give it. And thereafter, had annexure 1, we have rejected the claim, saying that the Lordship pays.
No, but portal has not been blocked according to you.
Has been blocked, not by the tender inviting authority.
But the registering authority.
Yes.
No, but here it says thereafter,
yeah,
about his unsatisfactory reply, then you will request chief manager.
Right,
So you have intimated about his unsatisfactory
Paragraph
reply.
1, annexure 1.
There are two aspects.
Right,
One, that there is no notice that you are going to block the portal.
No, but sir, one thing may intervene. There is no specific reason may be given that for blocking of the portal. The tender inviting authority is not the authority to block the portal. Portal blocking authority is somebody else. Only tender inviting authority, if he is satisfied that he has violated the conditions, he can only give a reason and the authority to block the portal. And that we have done, because if he was called upon.
So why the portal has been blocked? By whom?
By the if look at his document he has filed. the blocking of the portal at page
Is 126.
by the chief manager come, chief engineer come chief manager technical state procurement cell Odisha.
So he is also your officer.
Yes, my lord, our officer.
So was he justified in blocking the portal?
Because my lord, he failed to give the APS within time, my lord, violated the terms and conditions.
Then he
of
was
tender.
required to be given notice.
That my lord, I'll try to satisfy, my lord, that is the notice given.
That
by
is not the notice, because in the notice you will have to mention that this is the action which you have to take.
That we have stated that as per the tender provision, my lord.
At the tender procedure, we don't know what action you will be taking. So if you were going to take this action of blocking the portal, then you should have mentioned in the so-called notice that this is the action which you intend to take. Otherwise, you should be clear in your so-called notice and seeking explanation that because of this, we intend to do this. What is your reply? This is how. Otherwise, without disclosing the action which you intend to take, you could not have taken that action. All right, file your affidavits.
Yeah.
Let an affidavit be filed filed on behalf of
all the opposite parties also.
Of the opposite parties, particularly chief engineer. What is that?
Yes, whether he is a party or not, I don't know.
Yes, but the OP number 4 is the 3 and 4 is the both are the procurement officer, your lords. 3 and 4, your lords. Page 3 of the writ petition.
Lawsuit may say 4 and 5 notes, because 4 is the officer who blocks the portal and the tender conduct officer is 5 notes.
Let affidavits be filed. Let counter affidavits be filed on behalf of the opposite parties within 2 weeks. So it must be clearly mentioned in the counter affidavit as to whether any so-called notice was issued to the petitioner strictly in accordance with clause 20.3.
23.3.
No, sorry, 23.3 of the bid document.
Yes, sir.
Yes, it's only the part of the
document.
Of the tender document before blocking the petitioner's portal.
Yes.
So stop. List this case on and 4 weeks. 4 weeks.
Item number 18.
May I please, Your Lordship? Your Lordship, in this petition, the order dated 25/2024, passed by the Managing Director OSBC, cum mediator has been challenged, Your Lordship, in which claim of the
Mediator?
Yes, Your Lordship.
Which item is this?
18.
18. So,
Challenging order of the mediator.
before the division of it.
In which, Your Lordship, the claim of the petitioner was rejected, and the brief fact of the case is
Oh, there is the impugn.
Lordship Annex
decision.
8, page 79. ID. Lordship, the brief fact of the case is that
Are you challenging mediator's order?
Pursuant to order of this court.
Are you challenging
Yes,
it?
Your Lordship.
Yes, this is the opinion is incorrect, but this is not the manner in which the mediator is required to submit a report. And my was passed an order. So this mediation was conducted under which provision?
Your Lordship, under the clause of the one of the clauses of the agreement, Your Lordship, there was a dispute regarding the interpretation of a clause, and the petitioner approached this honorable court. As per the direction of this honorable court, liberty was granted to pursue the matter by mediation, Your Lordship, as per the mediation clause. And thereafter, this mediation case was filed by the petitioner, and the impugned order has been passed, Your Lordship. Your Lordship, I am challenging the order only on the basis of interpretation of the question of law is regarding interpretation of the word, Your Lordship, mischievous activities that has been used.
No. I'm trying to understand how this managing director, Orissa State Beverage Corporation, became a mediator.
As per the clause of the agreement, Your Lordship.
Where is that?
Your Lordship, it is there.
And 3 writ applications are pending. 3 writ applications are pending.
Yes, Your Lordship.
They have no connection with this.
They have different prayers, Your Lordship. This matter was referred for mediation.
No, different prayers, but not related to this dispute.
No, Your Lordship. Clause 49, Your Lordship.
Clause, where is that?
Clause 49, which is in
which page?
1 minute. In page 72, Your Lordship.
Page 72.
Yes, Your Lordship. Clause
Which
49.
clause 49. This is not. They don't understand
Mediation. What is this agreement, Mr. Samantrae? This agreement, look at page 72 clause.
It's Odisha Beverage Corporation.
They have separate counsel.
Council, we don't appear for them.
So under their advice, this must have been prepared.
All right, let us come to the impugned order.
Yes, Your Lordship. Your Lordship, the brief fact of the case is that the petitioner company is a company which supplies manpower, Your Lordship. And the petitioner was L1 and had executed.
We'll hear you on Monday. Monday.
Obliged, Your Lordship.
Some of the nursing matter, next matter, may I pray, Miller? Next matter, some of the nursing matter, it can be disposed of since some of the matter can be disposed, it is covered by your Lordship order.
The nursing
It will
matter.
take just 1 minute.
Item 19 and item 22, some nursing and pharmacy matters are there. 15, 10 can be disposed of, and another 5 I have taken get counted because first time the pharmacy, the time is extended up to 30th of November. And nursing, then INC has extended up to 30th of October, the admission.
So you do you
Monday
want
it can
any
be taken
order
up.
from this court?
Neither.
You want an order from this court. If you are satisfied
Yes.
that their grievances can be redressed, the grievances.
Yes, my lord.
Why waiting for an order?
No, my lord, similar matters have passed. Those because have covered cases, so that's why they want to get order for one honorable court. It's covered case. That denial of inspection. Monday let it take up. Monday can be taken up. This 1922.
Monday we can take up.
Yes, my lord.
Rest of the matter. Rest of the matter. Item 21. A tender matter against Paradipur Trust. I know after recess notes that better. So may I pray Monday you must be pleased to take up. All leftover matters on Monday. Fresh admissions on Monday. All leftover fresh admissions.
No, not only fresh admission. Other matters also. All the matters be taken up on Monday. After item. Why only such?
May I pray for 19 and 20 for 2 p.m. because that will consume at best 2 minutes of your lordship valuable time.
It will take, must make a mention in the morning.
Yes,
on Monday.
Yes. Yes.
Item 64, my lord. For item 64, that PIL, my lord, on the last occasion.
What is that?
The public interest litigation, my lord, the rare earth, that mining between Puri and Brahmagiri, my lord, in which notice was issued to IREL, the Government of India undertaking under the Department of Atomic Energy, my lord. That matter is listed today as item 64. If there is, I believe there is a 2 o'clock matter. So when it can be taken up at the earliest, my lord. That's what I'm praying, my lord. The response, the reply is yet to be filed by respondent number 3, my lord.
What is the urgency?
My lord, they have already evaluating the technical bid.
Oh, what? Why? What is there? There are so many matters pending.
My lord.
In the High Court.
My lord.
Some are languishing in jail for 11 years, 12 years. Some are not getting their pensionary benefits, tender matters, other mining matters. So how is your matter more important than all these matters? Why should your matter be taken up on Monday?
My lord, may I just make one submission? My lord, the third party right will be created, then it will again lead to other multiplicity of proceedings.
Third party right, with the moment you say third party right, and it gives an impression that you have some interest.
No, my lord, absolutely.
Absolutely not.
Absolutely not, my lord.
Be
My lord, the
careful.
response is not yet been filed.
Be careful.
My lord, I bow down to that, my lord. May I just say one thing? The response is yet to be filed, my lord. That is my whole.
All right. The response is no urgency.
My lord.
Response is no. We will see later.
So do you want us to fix another date?
Another date. Another date. Any other date.
Saturday.
God bless you.
Item number 29.
May it please your lordships.
Yes.
My lord, I just requested my instructing attorney to hand over a short list of dates for convenience. Miss Hu, if your lordships kindly grant leave, my lord. It's just a brief summary of the relevant dates. I'll just take your lordships, my lord, only to a few dates, so that, my lord, the point is clear. Will your lordship kindly see serial number 3 in the list of dates?
Yes.
21st of June 1999, the second renewal of this mining lease was executed by the state of Odisha on 21st of June 1999, extending the lease from 3rd of December 1997 to 2nd of December 2017. My lord, your lordships are then aware that there was the amendment in 2015. So please come to serial 5. The state of Odisha executed a supplementary lease deed with the petitioner on 1/12/2017, extending this lease up to 31st of March 2020 as per Section 8A6 of the MMDR Amendment Act 2015. That's why your lordships will find this date 31st March 2020 occurring in all the leases because they were statutorily, my lord, extended by virtue of operation of law. Now, my lord, please turn over the page and come to serial number 8. 6th of December 2019. In anticipation of the term of the mining lease coming to an end, the government of Odisha issued a notice inviting tender for auctioning this mining lease. An e-auction was conducted in February 2020, and the petitioner was declared further for grant of the mining block for a period of 50 years. Then, my lord, please come to 2nd March 2020, the next date. Pursuant to the petitioner being declared the preferred bidder, a letter of intent was issued to the petitioner on 2nd March 2020. My lord, may I now request your lordships to just look at this annexure in the writ petition documents. Please just come to, my lord, annexure 3, which would be at page, my lord, in the print, page 169. This is the letter of intent. My lord, this is in the writ petition.
Just a minute.
Yes, I'm sorry, my lord.
Yes.
My lord, at page 169.
Yes.
I trust her ladyship has also the page. This is, my lord, of writ petition 18740 of 2021.
Just a minute, Mr. Just a minute, Mr.
Yes, certainly, my lord, certainly. It's annexure 3, my lord. Annexure. My lord, this document say March 2020, and it is written by the government to the petitioner, letter of intent with reference to e-auction dated 3rd of February 2020 for grant of a mining lease for Balda block of for iron ore in Balda, Bada, Kalimati, Nayagad villages, Kenja district over 343.981 acres. And your lordships will find in the recital in para 1.1, Government of Odisha, pursuant to the MMDR Act and the auctions as amended from time to time, issued the notice inviting tender dated 6th of December 2019 to commence the auction process for grant of mining lease for Balda iron ore block located in Kenja district of Odisha. The e-auction process was conducted in accordance with the tender document for the said mineral block, and Messrs. Sirajuddin was declared as the preferred bidder under Rule 993 of the mineral auction rules, having quoted a final price offer of 118.05. Over the page, my lord, at 170, your lordships will find, accordingly, pursuant to Rule 10.2 of the auction rules and the terms of the tender documents, the government of Odisha is issuing this letter of intent for grant of mining lease for Balda block for so-and-so for a period of 50 years. And then in 3.1, this letter of intent and subsequent grant of aforementioned mining lease shall be subject to the provisions of the Act and the rules made thereunder as amended from time to time, and Sirajuddin and Company shall be designated as the successful bidder and granted the mining lease upon satisfactory completion of all the requirements under the Acts and the rules made thereunder. Now, my lord, after this is on 2nd of March 2020, please come to item 11, my lord, of the list of dates, 10th of June 2020. And that your lordships will find is annexure number 5, annexure 4, my lord, which is at printed page 174. It is called a vesting order.
Yes.
And in this vesting order, my lord, it's of some significance Whereas a mining lease, my lord, that is the recital. Your lordship finds the mining block is described, the area of lease is described, letter of intent is referred, and now please come to the penultimate recital at page 174. And whereas in terms of section 8B2 of the MMDR Act 1957 and read with Rule 9A4 of the Mineral Concession Rules 2016, the holder of letter of intent for the said mining block shall be deemed to have acquired all valid rights, approvals, clearances, and licenses, and the like vested with the previous lessee. And your lordships will find that the same, my lord, is repeated at the last para also. Same words are repeated. So, my lord, there is a continuum that the new lessee will have the rights of old lessee when your lordship sees this vesting order. And over the page, your lordships will find that this, my lord, is granted. This is a vesting order till the execution of the lease deed. And then your lordships will also notice that there is an annexure, which is at printed page 177. And your lordships will find serial number 6 in that document. Surface right granted over 244.651 hectares.
Yes.
Now, my lord, on the 8th of July, if your lordship goes to item 12 in the list of dates, 8th of July 2020, the government of Odisha executes a mining lease, a formal lease, and your lordships will find that at printed page 178. It begins, my lord, and the relevant portion for us is only one recital, which my lord describes. Please come to page 184, my lord, page 184.
Yes.
The lessee had participated, my lord, I've already read that, and then pursuant to which the lessee has become eligible for grant of mining lease with a order dated 7 July 2020, with respect to which the lessee has completed the requirements under the Mines and Minerals Development and Regulation Act 1957 and rules made thereunder for grant of mining lease. Accordingly, the state government is now executing this deed for grant of a to the lessee in consideration of fee, royalties, covenants, and agreements, and contained on the part of the lessee to be paid, observed, and performed. And your lordships will find 2.1. The state government grants a lease over an area described in the lease area. My lord, this word, this expression lease area will become relevant once we look at the rules immediately. For conducting mining operations for a period of 50 years, commencing from the date on which his duly executed mining lease is registered with respect to the following mineral, iron ore. The lessee shall be, with respect to all those mines, beds, veins, and seams of the minerals situated, lying, and being in or under the lease area. Subject to the lessee paying so and so, then, my lord, he will quietly hold and enjoy the rights and premises of the lease area for and during the term hereby granted, without any unlawful interruption from the state government or any person rightfully claiming under it. Now, my lord, why is it without any unlawful interruption from the state government? Your lordships may just make a note on the side, which is section 8 capital B, my lord, of the MMDR Act. That is, my lord, what is incorporated. Now, my lord, this is on the 10th of June 2020, 8th of July 2020, and the 50 years lease is granted. Notwithstanding, my lord, the fact that he is the new lessee, he has taken possession, he is the lessee in that place. My lord, these two notices are issued the 1st of October 2020 under Rule 12(1)HH, and, my lord, the notice dated 9th of October 2020 rejecting an application under 12(1)FF. These are the two notices, my lord, which were impugned in the writ petition which was filed by my client before the High Court. Now, my lord, what is the point at issue? If your lordships will now just take the two rules, relevant rules, they need, my lord, an interpretation from the court. And that is 12.1 GG and 12.1 HH. Let us look at these two rules, my lord. Please see, my lord, 12.1 GG. I've already, my lord, indicated that these are conditions of the lease.
Yes.
The lessee may, after paying the rents, rates and royalties payable under the Act and rules made thereunder or under the lease deed. Now, my lord, the next few words are important. At the expiry or sooner termination of the lease term or within 6 calendar months thereafter, unless the lease is terminated for default of that lessee, and in that case at any time not less than 3 calendar months, nor more than 6 calendar months after such termination, take down and remove for its own benefit. Take down and remove for its own benefit all or any ore, mineral excavated during the currency of the lease. My lord, the crucial words are currency of the lease. Machinery, plant, buildings, structures, tramways, railways, and other works, erections and conveniences which may have been erected, set up or placed by the lessee in or upon the leased lands, and, my lord, the next few words, which the lessee is not bound to deliver to the state government or which the state government does not desire to purchase. So, my lord, my submission is that under 12.1 GG, it is contemplated that the lease is expiring and the person is going to leave the leasehold area. And because he is going to depart from that leasehold area and a severance is going to happen from the physical occupation and possession of that leasehold area, therefore he is granted, my lord, that time of 6 months to take away the ore, take away the machinery, because he is not lawfully bound to deliver this to the state government, and the state government does not intend to purchase it either. And 12.1 HH also, my lord, now please look at it. It also postulates that there is an old lessee and the old lessee will be replaced by a new lessee, a different lessee. If at the end of 6 calendar months, after the expiry or sooner termination of the lease term, there shall remain in or upon the leased land any ore or mineral, engines, machinery, plant, building, structures, so and so, so and so, which are not required by the lessee in connection with operations in any other lands held by it under a prospecting license or mining lease. The same shall, if not removed by the lessee within 1 calendar month of being notified to do so by the state government, be deemed to become the property of the state government and may be sold or disposed of in such manner as the state government shall deem fit, without liability to pay any compensation or to account to the lessee in respect thereof. But here, my lord, the crucial words are not required by the lessee in connection with operations in any other lands held by it under a prospecting license or mining lease. So, my lord, severance is the heart of 12.1 GG and 12.1 HH, because 12.1 HH, my lord, comes only after the expiry of 6 months. So, my lord, the condition of severance of a lessee from the physical area is the sine qua non or quintessence of Rule 12.1 GG and 12.1 HH. And, my lord, my submission is, if that condition is absent, then, my lord, there is a want of jurisdiction to act under 12.1 HH, because you can't act under 12.1 GG in the first place. my lord, you can come to 12.1 HH only when you have walked through the gates of 12.1 GG. And if you cannot walk through the gate of 12.1 GG because the leased area is with the same lessee, then admit 12.1 GG and HH are not applicable. If they are not applicable, my lord, these orders and notices are sans without any jurisdiction because they are not applicable. They are applicable to a lessee who is parting from the lease area.
Yes.
They apply, my lord, to a lessee who actually now is picking up his bags so he can take his ore, plants and machinery. Now, my lord, what is the stand of the state government in the impugned order and in the counter? Very simply put, they say once a lease is terminated, it does not matter that you become a new lessee. Whether you are a new lessee or an old lessee, you are duty bound to take away in terms of 12.1 GG, the plant and machinery, as well as the ore. And that is where, my lord, we have the contention between the parties. And according to us, my lord, the rule contemplated severance of status. But fortuitously, if for some reason the severance of status does not happen, then it is a case where, my lord, the state has to keep its hands back and cannot act under 12.1 GG and 12.1 HH. My lord, this, if I may say so, is noticed by the division bench. Now let me take you, my lord, to just 2-3 paras on this point in the division bench judgment. The division bench notices this peculiarity. And if your lordship look at the judgment of the division bench for a moment, my lord, please see.
Which page?
My lord, this is at paragraph number 29, my lord. If your lordships just kindly comes to, my lord, may I first show para 3 first? Para 3.
No, but whether that judgment has been annexed is...
my lord, this, if I may say so, my lord, I am given to understand has been...
Flag Y. Flag Y.
Flag Y.
Flag Y. I'm grateful. My lord, if your lordship sees printed page 7 and para 3.
Just a minute. Which paragraph? Which page?
Para 3, my lord. Page 7. Printed page 7, para 3.
Yes.
In the second category are the cases in which after expiry of the lease period of the old lessee, the leasehold area has been put to work, and the very same lessees having been given the highest bid have again became the fresh leaseholder. Writ petition number 27672 of 2020 falls in this category, which has been filed by Ghanshyam Misra and Sons Private Limited, and writ petition 28141 filed by Sirajuddin and Company falls in this category. So, my lord, this is also noticed. Now, my lord, the submissions in this regard are in para 29. Please see para 29. Which is at printed page 43, my lord.
Yes.
The arguments were common, my lord, in both these writ petitions. Para 29. This writ petition has been filed at the instance of Ghanshyam Misra and Sons seeking to challenge the order of the competent authority dated 1/10/2020 as well as the order dated 9/10/2020. While challenging the orders at 3 and 4, petitioner also seeks a direction for grant of 6 months' time or such other time as this court may deem appropriate to meet with the loss of time sustained due to COVID-19 by applying force majeure clause. Mr. P.S. Narasimha, learned senior advocate appearing, taking this court through the pleadings of the writ petition and referring to 12.1 FF, 12.1 GG, and 12.1 HH, and different circulars issued by the central government, as well as state government submitted, that the accepted position is that the entire world has suffered due to COVID-19 pandemic. The basis for invoking force majeure clause to the case of the petitioner is very much available. Requesting the court to take judicial notice of the pandemic situation prevailing in the country for quite a long time, learned advocates submitted, there is absolutely non-application of mine by the competent authority to the overall situation before passing both the impugned orders. It is contended that the petitioner's case is completely different than those of the old lessees in other cases. Here in the present case, the petitioner who is the old lessee is also the new lessee for the very same leasehold area after the expiry of the previous lease on 31/3/80. Well, please just go down 5 lines. The provision contained in Rule 12.1 GG of the rules has thus no application to this case, for the requirement of plants and machineries used previously by the same lessee would still be there. Moreover, ownership of the minerals excavated by the petitioner as an old lessee shall continue to be vested in the petitioner. Learned senior advocate therefore contended that there was in this case no question of the new lessee transporting the minerals or the plant and machineries under 12.1 GG and also visiting through the provision of 12.1 HH of the rules of 2016. On the issue of parties being provided with a scope for having intermediate storage in a nearby area to transport their stock of mineral by virtue of the notification of 4 September 2020. My lord, it is actually 4th October 2019. It's a typographical error. Mr. P.S. Narasimha, learned senior advocate, submitted. Since herein the old lessee itself became the new lessee, there was no occasion for him to go for intermediate storage facility, as he can very well manage the properties on the same leasehold area during subsistence of the new lease. In these circumstances, learned senior counsel contended that competent authority has mechanically applied 12.1 GG and 12.1 HH to the present case, and therefore both the orders are not sustainable under law. And ships will notice that this same point, my lord, please see at page 46, bottom, the last 4 lines. In this regard, the petitioner made repeated representations to the authorities, requesting them to permit the mineral excavated prior to 31/3 at the very same mining leasehold area beyond the period of 6 months as provided for, as the petitioner itself is a new lessee. This special feature of the case of the petitioner under these circumstances ought to have engaged the attention of the opposite party. Sorry, my lord. I'm so sorry.
Please continue, Mr.
I'm so sorry, my lord. I
It's
just
all right.
was
All right.
sorry. And then, my lord, this argument is adopted in para 33 in my client's case, in Sirajuddin's case, identical, my lord. It's adopted. This argument is adopted. And your lordships will find at printed page 49, 10 lines from the top. Learned counsel. Printed page 49, my lord.
Yes.
Learned counsel therefore submitted that the provision of 12.1 GG and 12.1 HH of the rules of 2016 can be hardly applied to the case of the petitioner. And then, my lord, thereafter, in para 34, there is the argument that the property of a citizen cannot be taken away. And, my lord, Article 300A is also cited. Now, my lord, after this, if your lordships will kindly look at para 50. My lord, please see paragraph 50 at this moment. My lord, in paragraph 40, in fact, my lord, I should start from paragraph 48 because, my lord, the authority has started the quotation only from paragraph 49. But it is paragraph 48, my lord, that deals with COVID. And then, my lord, there is a mention of force majeure. And in 49, the court says that we are inclined to uphold that force majeure deserves consideration. And in paragraph 50, your lordships will notice, my lord, our case is dealt with, paragraph 50. This court, on examination of the individual cases, finds that the petitioners in the first category of cases made representation seeking additional time for transportation of mineral, as well as plant and machineries, whereas the claim of the petitioners falling in the second category was based on the fact of the old lessee becoming the new lessee. This group of ex-lessees claimed mineral, plant and machineries, etc. for their own requirements. Their cases that Rule 12.1 GG, 12.1 HH would not be applicable to them because they would continue as the leaseholder in the same leasehold area for another 50 years. These questions have not at all been examined by the state authorities while deciding their representations. And then the last 4 lines, my lord, in paragraph 50, they contend, my lord, that what is the point of our dictionary and bringing them back? And what is the point of taking the ore and bringing it back, my lord, for usage or for further beneficiation? And after this, my lord, your lordships may kindly come to paragraph 59. I will only request your lordships to note this para because the para says, my lord, there is non-application of mind. There is no reason which is attributed. Individual facts have not been taken into account. And this is, my lord, the quintessence of para 59. And after para 59, your lordships may kindly come to para 76. Considering the case of the petitioners from the perspective, well, this is printed page 105.
Yes, we are there, Mr.
Yes, based from the perspective that despite peculiar and different facts of different cases, well, this is critical. Despite peculiar and different facts of different cases, non-consideration of each individual case, separately invoking 12.1 GG, while representations of the petitioners were pending, with a order dated so-and-so. My lord, that's 12.1 HH, my lord. GG is a typo. It is an error. It is 12.1 HH. With a order dated 1/10/2020, and then rejecting all the representations by identically worded cryptic and non-speaking orders, this court is inclined to hold that this is a case for it to exercise its power of judicial review by requiring the respondents to reconsider the representations of the petitioner, at least in the first 5 of the above petitions, anterior to the stage of invocation of 12.1 GG, when such representations were pending with them, and straightaway allow the last 3 petitions where petitioners have not invoked force majeure or have been otherwise able to make out a case independent of measure on account of arbitrary exercise of power. And therefore, my lord, para 77, on analysis of the entire materials, we are inclined to hold that the petitioners in 5 writ petitions, my lord, my client is 28141, and the other petitions, wherein they have mainly prayed for invocation of force majeure, with reference to clauses 4, 5, 6, and part 9, the impugned order passed by the authority invoking 12.1 HH, while keeping representation of the petitioner pending, an order dated 9/10, while dismissing representations as not maintainable, having been passed without considering any of the arguments of the petitioners that the force majeure event is attracted in the circumstances, deserves to succeed in part. And now, my lord, your lord shall notice, we therefore, while partly allowing all the aforesaid 5 petitions, set aside the orders of 110-2020, invoking 12-1 GG, and the order dated 9-10-2020, rejecting the representations, and remand the matters to the Principal Secretary, Steel and Mines Department, Government of Odisha, for considering the representations of the writ petitioners afresh in the light of the discussions made above. And petitioners would be at liberty, my lord, to submit representations and so on. Now, my lord, a representation is elaborately made, and your lordships will find this representation, my lord, is in the writ petition. And please see, the representation is Annexure 13. And my lord, what precisely the division bench said you should not do, namely lump everybody together and not look at individual facts, is precisely what the impugned order does again. Now, my lord, let us see this representation. It is Annexure 13. It begins printed page 206. I'll straight away take your lordships to the point. Please come, my lord, to printed page 215. Issue Roman 1. Rules 12.1 GG and HH of the MCR are not.
You are referring to, Mr. You are referring to the page?
215. 215, my lord. 215.
Yes.
Your lordship finds representation stroke submission. First point is rules 12.1 GG and HH of MCR are applicable in the case of a continuing lessee. So, my lord, if I succeed in this point, I really don't have to labor any other point. That namely, these two rules are not applicable when I am the new lessee in respect of the same area. And a bare and a plain reading would indicate that the 6-month period is granted.
Mr. Subramanian.
Sorry, my lord.
This point was specifically taken by you in the
yes.
Earlier batch of
yes, my lord.
Earlier litigation.
Yes.
So, what is the opinion? Is there any definite opinion?
My lord, the court says you must consider the individual facts of each case, which are peculiar to each case. It notices, my lord, my submission that I am a new lessee continuing. I mean, the old lessee continuing now as a new lessee. This needs to be considered. My contention, my submission has to be appreciated by the state. My lord, the court, my lord, this is done often. First gives, my lord, an opportunity to the executive government to act in accordance with law. And therefore, my lord, the court says you consider the representations and pass an order. And the first submission, my lord, in the forefront from paras 27 to 37 of this representation, my lord, para 27 right up to para 37 is all on the basis of 12.1 GG and HH not being applicable. Because, my lord, it would lead to absurd consequences.
Should we go back again to the direction issued by
yes, certainly, certainly. Would your lordships kindly come, my lord, to the judgment itself? Please see that, my lord, for a moment. If your lordships will kindly see for a moment, my lord, I mentioned, if your lordships will see, para 50 first, my lord, and then I'll give the operative portion. Please see.
Yes, please.
If your lordships will kindly see, at para 49 and then para 50, this court on examination of the individual cases finds, that's printed page 77, my lord.
Yes.
Yes. This court on an examination of the individual cases finds that the petitioners in the first category of cases made representation seeking additional time for transportation of mineral as well as plant and machineries, whereas claim of the petitioners falling in the second category was based on the fact of old lessee coming new lessee. This group of ex-lessees claimed mineral, plant, and machineries for their own requirement. Their case is that Rule 12.1 GG and 12.1 HH would not be applicable to them because they would continue as the leaseholder in the same leasehold area for another 50 years. These questions have not at all been examined.
This is what we wanted to see. Mr.
Yes, yes, my lord. This is the, and while deciding their representations, their case is that the opposed parties have allowed the facility and so on. Further, they contend they would still require plant and machinery when they come back. So, my lord, this is really the scope as far as the second category of lessees is concerned. And that is why, my lord, in paragraphs 27 to 37, and if your lordships will kindly see that sentence in paragraph 50, the last 5 lines.
But what is the final this thing conclusion and directions?
My lord, this is my lord, they have come to a conclusion that these have not been examined by the state authorities. Therefore, my lord, by virtue of this, if your lordships will then kindly come to paragraph 76. Therefore, my lord, they say that individual cases have to be considered. Please see, my lord, for a moment, paragraph 59 first, my lord, in continuum at printed page 92, my lord. Paragraph 59 first.
Yes.
In the case at hand, this court finds that the impugned orders dated 110 and 910, both for its nature and taking into account the arguments in assailing them, suffer on account of committing breach of rules of natural justice, where state authorities arrived at a decision being totally mechanical, without in the least assigning any reason whatsoever, which reflects total non-application of mind. And further, they also suffer from being irrational and passed in gross abuse of powers and attaining to procedural impropriety. The first order under 12.1 HH was passed without considering the representations of the petitioners, in which they requested the respondent state to invoke 12.1 FF in their favor, and the second order dismissing the representation was not maintainable. This, in our view, is a fit case where the High Court needs to exercise of its power on judicial review. And then, my lord, they finally go to, if your lordships will kindly see, they say in paragraph 76.
Yes.
The first 3 lines, my lord.
Yes.
Considering, this is printed page 105, my lord. Considering the case of the petitioners from the perspective that despite peculiar and different facts of different cases, non-consideration of each individual case separately invoking Rule 12.1 GG, while the representations of the petitioners was pending by an order and then rejecting all the representations. Yes. So, my lord, this is the net effect. And therefore, my lord, now the impugned order deals with the contention, my lord. It is not that taking it is saying, yes, I'm duty bound to consider this submission. So, paras 27 to 37, my lord, of my representation, they say that these 2 rules are not applicable. And, my lord, the order which is impugned, that is the order which has been passed, if your lordships will kindly look at that order for a moment, the relevant portion on this point, my lord, are 3 paras, my lord, 54
which
to 56. Annexure? This is, my lord, yes, annexure 15, my lord. That's the impugned order.
Yes.
The order which they passed, my lord, finally on my representations. And here, my lord, their position is, from paragraph 54, their point is, there is no distinction which the law warrants if you are a new lessee. This is, my lord, their sole sheet anchor.
Paragraph?
Paragraph 54. So, my lord, the division bench said, please consider these cases distinctly because they have peculiar facts. You'll have seen that in the division bench judgment. And please see the opening words of paragraph 54. They lump everybody together. The opening words. that there are 24 mines, including that of the petitioner lessee, validity of which expired on 31/3/2020, that as per the provisions contained in Rule 12(1) GG and HH, the lessees of all the 24 mines, including the petitioner lessee, are covered under 12(1) GG, 12(1) HH by virtue of the respective lease deeds, validity of which expired 31st March 2020. But, my lord, within that period, I have become a new lessee. Even before 31st March, I have a letter of intent. I am the new lessee. So how does, my lord, 12(1) GG, and therefore, my lord, in paragraph 55, they plead that we have to treat everybody alike. Those who have gone out must be treated exactly like the ones who have become the new lessees. And that, my lord, is error of law. This, my lord, is unequals being treated as equals. And, my lord, this completely makes a mockery of the intendment of 12(1) GG and 12(1) HH. Which is why, please now see, my lord, in paragraph 55, they say that there is no scope at all for us treating you in any manner differently from other ex-lessees. And this is, my lord, the error. Please see 55, the first few lines. At the outset, it will be appropriate to examine the claim of the petitioner as to whether the petitioner was in any manner differently placed other than the ex-lessees whose mining leases had expired along with the petitioner, and whether the rules of 12(1) GG and HH were applicable to the petitioner or not. Upon scrutiny of facts, it is abundantly clear that the petitioner was one of the 24 lessees whose mining leases had expired. He is therefore equally placed with all the 23 lessees. Thus, the provisions of 12(1) GG were applicable to the petitioner. Like every other lessee, the petitioner was mandated to remove the minerals lying within his lease area within 6 months as per the provisions of 12(1) GG. All these 24 mining blocks were put to auction by the state government. Thereafter, my lord, it is not thereafter, it is even before the expiry of 6 months, the petitioner won the very same mining block in auction and was declared the successful bidder. The issue here is that law provides that the ex-lessee dispose of his old stock within the prescribed time of 7 months. Merely because the petitioner became a new lessee, also for the self-same block, does not qualify him to be extended any benefits beyond the law. My lord, I'm only asking the law should be made applicable if it is applicable. Can it apply to a person, my lord, who is not having a severance with the land? That is the question. If, my lord, I as an ex-lessee, I'm not severing my relationship with the land, and I become the new lessee, and now I'll show to your lordships, my lord, two provisions. Section 8B of the MMDR Act. And they will, my lord, put it, my lord, completely beyond a pale of doubt. 8B 1 and 2. Please see this, my lord, with me. If your lordships will kindly see 8B. 8A, my lord, is the period for which the minerals can be granted by an auction. Then 8B. Provisions for period and transfer of statutory clearances. Please mark, my lord, 8B1 and 8B2. Notwithstanding anything contained in this act. Your lordships notice that, my lord?
Yes, yes.
Yes. Or any other law for the time being in force, all valid rights, clearances, licenses, and the like granted to a lessee in respect of a mine and under the provisions of so-and-so shall continue to be valid even after expiry or termination of the lease,
You are reading subsection 2 of section 8 capital B.
8B1, my lord. First 8B1.
8B1.
1. Please. Yes, I'm sorry, my lord. May I just read it again?
Yes, please.
8B1. Notwithstanding anything contained in this act or any other law for the time being in force, all valid rights, approvals, clearances, licenses, and the like granted to a lessee in respect of a mine shall continue to be valid even after expiry or termination of lease, and such rights, approvals, clearances, licenses, and the like shall be transferred to and vested, subject to the conditions provided under such laws, in the successful bidder of the mining lease selected through auction under this act. So, my lord, when a lessee parts company from that area, what all approvals he has are then going to vest in the new lessee. That is the auction purchaser. So, my lord, the auction purchaser or the successful bidder actually now is entitled to the fruits of all rights, approvals, clearances, and licenses of the old lessee. And this, your lordships will find, is iterated in 8B2 also. 8B2, 8B1 and 8B2.
Yes.
Notwithstanding anything contained in any other law, for the time being in force, it shall be lawful for the new lessee to continue mining operations on the land till expiry or termination of mining lease granted to it, in which mining operations were being carried out by the previous lessee. So, my lord, your lordships notice that there is a vinculum juris, a link which is established between the old lessee and the new auction purchaser. So the new auction purchaser, my lord, the new lessee, steps into the shoes of the old lessee and continues the mining operations.
Yes.
So, my lord, if this is the statutory intendment under 8B1 and 8B2, the reasoning which is contained, my lord, in para 55 of the order, that 12.1 GG and 12.1 HH will apply even to a new lessee, is contrary to 8B1 and 8B2.
Yes.
That is why, my lord, you have a non-obstant clause both in 8B1 and in 8B2. In 8B1, my lord, it says notwithstanding anything contained in this act. And in 8B2, notwithstanding containing in any other law for the time being in force. So these two non-obstant clauses, my lord, make it clear that the auction purchaser will enjoy all the rights and approvals and clearances and what is demised to the old lessee. So, my lord, which we urge before the government, that 12.1 GG and HH does not have an application when there is no severance. When, my lord, the auction purchaser and the old lessee are the same. That, my lord, is the point, my lord. And your lordships will notice in para 55, that is exactly what, my lord, they say, no, we must consider you at par with all others. My lord, it might look facial equality. My lord, this is not, in this case, it is not even de jure equality. It is only a facial equality to say, technically your lease expired. Because your lease expired, you were necessarily subject to the regimen of 6 months and 1 month. But, my lord, that is a facial equality. It is not the de jure equality which the Act and the rules themselves contemplate. For which, my lord, I submit that Rule 12.1 GG and 12.1 HH if they are informed by the principle of purposive construction of statutes, then, my lord, what is the purpose? The purpose is to benefit a lessee who is parting the leasehold area, who is leaving, my lord, the leasehold area, who is being asked to go away from the leasehold area. That is why, my lord, under 12(1) GG, your lordships will find the words which are used are leased area and, my lord, expiry of the lease. My lord, what is important is there is an expiry. There is no resumption under 12(1) GG. There is no new lease under 12(1) GG. There are three, my lord, instances in 12(1) GG. Either expiry, my lord, or premature termination of the lease, my lord, or a termination on account of the default of the lease. If your lordship see 12(1) GG, the words, my lord, when we view it through the lens of purpose of interpretation, then, my lord, it is clear that it poses no difficulty. Your lordships will find the crucial words are the expiry or sooner termination of the term, lease term, or within 6 calendar months. And please see, my lord, the crucial words: take down and remove for its own benefit all or any ore mineral excavated during the currency of the lease, engines, machinery, lands, etc., and which the lessee is not bound to deliver to the state government. So, my lord, the intendment is very clear. It is a parting lessee who must not be deprived of the usufruct or the fruits of his labor in the extraction during the currency of the lease. This is, my lord, the intendment of 12(1) GG. And if this is, my lord, the purpose of 12(1) GG, this purpose, my lord, is not subserved when the old lessee becomes the new lessee.
Yes.
This is the point, my lord. Once the old becomes the new, then, my lord, this intendment is irrelevant. This beneficial intendment, my lord, completely is rendered otious.
Yes, we have got the point, Mr.
That's right. I'm very grateful, my lord. And, my lord, your lordships will notice this reasoning goes on till paragraph 56. And as I, my lord, mentioned yesterday, please see this undue and unlawful benefit to the petitioner. My lord, I'm not asking for any charity. I'm saying under the law, these two rules don't apply to me. So, my lord, what is actually put against me at printed page 341 is if I had to sell the ore like other ex-lessees, then the other ex-lessees may have been compelled to sell at a lower price.
Yes, please.
Yes. So, my lord, at page 341, printed page, my lord, this is the error. And this is a complete misdirection in law. My lord, the price at which ore is sold is not for 12(1) GG or 12(1) H at all. And, my lord, this at printed page 341, in the middle of the page, please see this. If any extension of time, my lord, it is in the latter half of that page, printed page 341.
Yes.
If any extension of time is granted to the petitioner on the grounds that he is the new lessee and that the mineral is not causing inconvenience to any other new lessee, would imply granting undue unlawful benefit to the petitioner. My lord, this is completely arbitrary reasoning, my lord. It is irrational. It has no basis. There is no benefit to me at all.
Yes.
And then the next sentence, disposal of stocks has been done by other similarly placed lessees within a short window of time. Again, my lord, lumping everyone together.
Yes.
And then the next one, there is a possibility that sale could have been at prices lower than expected as there was race against time for the lessees to sell their ore. My lord, where is all this coming from the rule? none of this is relevant to the rule. Those lessees did not have the comfort of waiting for prices to rise and had to dispose within short time. As evident, the present petitioner did not dispatch at the same rate as done by other similarly placed lessees. My lord, I am the new lessee. And this, my lord, I submit with great respect, is completely a misdirection in law. And this is an error of law, my lord, which attracts your lordship's application of the powers of judicial review. And this, my lord, is now if any extension of time is granted, just because he is the new lessee, will be prejudicial to other similarly placed ex-lessees and will give him unfair advantage of profiteering, not abiding with law. My lord, this is a complete misconception. So, my lord, bracketing me with all other ex-lessees, including those who have not been successful in the auction, is an error of law. So, my lord, when there is a duty to distinguish lessees from each other, it is a duty warranted in law. And there is a failure, my lord, to carry out that duty because 8B itself, my lord, has not been appreciated. The terms of the vesting order, which I showed your lordships, the terms of the lease deed, which said you will have the same rights as the previous lessee, none of this is considered.
Yes.
And then, my lord, therefore, what is then said in paragraph 56, critical, my lord, is again lumping me with 23 other lessees in the middle of that paragraph. The declaration of being successful in an auction in no way changed his status of an ex-lessee who was required under law to dispose of his leftover minerals within the lease area. Does your lordship notice that line, my lord? In the middle of paragraph 56.
Yes.
This, my lord, is an error. And this, my lord, is the error which vitiates our order as far as I'm concerned. Because I cannot be treated as an ex-lessee when I'm a new lessee in continuum. And if the law permits a continuum, and I am that fortuitous person who is continuing as a new lessee, then, my lord, 12.1 GG, 12.1 HH will not apply. Now, my lord, after having said all this, your lordships may kindly come to what is done at the end is please see paragraph 7 at page, my lord, 352.
Yes.
Please see page 352, paragraph 7.
You're there.
Yes, my lord. That the petitioner lessee, being the present leaseholder of the mine, his contention that he would still require plant, machinery, and other equipment for running the mines, and he should not be compelled to remove them to ultimately bring them back, appears to have merit of being considered. But Lord, I think it very difficult, my lord, really to follow this logic.
Yes, please. Yes.
And then further, obviously, the petitioner being both the old and new lessee, he need not remove his plants, machinery, and other infrastructure. Then, my lord, why should I take away the ore? Because the rule uses the word ore along with machinery and tramways and equipments. Expecting the lessee to remove the same and again reinstall would wrong. Hence, this prayer of the petitioner is allowed to the extent that he is not required to remove the plants, machineries, and other infrastructure from the leased area under 12.1 HH. So, my lord, in para 76, there is an admission that I am both the old and the new. And there is no question of irrationally asking me to take away the machinery, which can only, my lord, predispose to the conclusion that 12.1 GG and HH were not applicable. Therefore, my lord, allowed plant and machinery and said take away the ore. And therefore, my lord, in 77, I read yesterday, my lord, your lordship has seen the first prayer And the second one, they don't go together. The first direction and the second. The second is you keep the machinery. The first is I don't give you extension of time.
Yes.
So, my lord, 1 and Roman 2 do not coalesce together. They cannot, my lord, coexist with each other. And that, my lord, inconsistency has happened because the right legal standard or yardstick for applying 12.1 GG and 12.1 HH was that there is a severance of status as a lessee and the property, the leasehold area. And that severance, my lord, is critical. And then your lordships may find 12.1 HH, my lord, is straight away invoked. And then Roman 4, I've already explained, my lord, that there was this exemption from stacking and sampling, which I wanted to be withdrawn, which was pending. That, my lord, in one para, they said it was completely false. In another para, he says, well, I allow the director of mines to consider it. My lord, this is my first point. I now, my lord, come to the second point. I told your lordships there are 3 points. I'll come to the second and the third quickly. The second point, my lord, is come to Annexure 16 of the writ petition.
Annexure
16, which is printed page, my lord, 361.
Yes, we are there.
Now, my lord, what happened? Your lordships must know. This is 4th October 2019. So even before 31st of March 2020 arrived, the state government said to the lessees, we will give you permission to take, store it at some other storage or depot and keep it with you, not for 6 months, my lord, up to 31st of March 2022 to enable you to sell the ore. And you pay royalty as and when you sell. Please see this, my lord. Permission for intermediate storage in favor of merchant mining lessees whose leases are expiring on 31st March 2020. And whereas the validity period of large number of operating mining leases is going to expire with effect from 31st March 2020, and whereas state government have taken steps to facilitate smooth transition of such mines post 31/3/2020, and whereas huge quantity of stock is lying in these lease areas, and its evacuation from the lease area is in the interest of smooth operation of the mines by the new lessees after the expiry of validity period of existing leases. And whereas the proposal for permitting intermediate storage in favor of mining lessees whose leases are expiring on 31st March 2020 was thus under active consideration of the government. Now, after careful consideration, the state government in exercise of powers vested under Rule 10B of the Odisha Mineral Rules 2007 have been pleased to allow establishment of intermediate storage the merchant mining lessees whose leases are expiring on 31st of March 2020 in relaxation of the provisions of 6 Proviso to Rule 3 and also subject to the following conditions. And your lordships will notice the storage license shall be valid only for storage of iron ore or manganese or chromite for the maximum period up to 31st of March 2022. So, my lord, the submission was, if you are permitting an lessee to actually establish a storage depot and store the mineral up to 31st of March 2022, my lord, that's 2 years, then our submission before the state government was, I am the lessee of this leasehold area. Why don't you allow me to keep this? If this is my leasehold area, the ore belongs to me, why can't I keep it? It was, my lord, on the basis of parity of this notification. of 4th October 2019. That, my lord, your lordships will find this is noticed in the division bench judgment. This contention, my lord, the submission is noticed in para 50 of the division bench judgment.
Paragraph 58.
Yes, 50, my lord. 50. This is noticed, my lord. And then, my lord, the representation by the petitioner on this is at printed page 221 of that annexure 13, my lord, which I showed you. That representation.
Yes.
And in that, at page 221, my lord, your lordships will find there is the point made with reference to this particular notification. It comes under a caption, my lord. Lessee is entitled to extension till 31st March 2022 to remove the materials in terms of notification dated 4th October 2019. And this, my lord, is rejected by the government. Your lordships may note the two paras 58 and 59, saying you should have established a depot. You are like an ex-lessee.
Yes.
So, my lord, this is the second point.
Yes.
And now I come, my lord, to the third point. The force majeure. My lord, the reason why the division bench quashed the orders was it said that everybody will have his own facts. Why he was not in a position to lift the oar. So, my lord, it said that on force majeure, each individual lessee's case must be considered. My lord, if I succeed on the first point or the second, this third point is not needed for me. But I'm arguing it, my lord, by way of an alternate submission. Now, my lord, the division bench, my lord, these paragraphs have been read to your lordships. I'll just give the para numbers if your lordships can note them down. Paras 48, 49, 60, 61, 76, and 70. These are the paras, my lord, which touch on force majeure. Now, my lord, this required an individual consideration because every lessee, my lord, was not placed in the same boat.
As has been argued by Mr.
Yes,
Singh.
yes. And I completely, my lord, respectfully, I agree with his very learned and persuasive submission that, my lord, the situation was not different. And, my lord, the stand taken by the state government initially in the first round of litigation was force majeure does. This is not force majeure. This is onerous burden. But onerous burden is not the same as force majeure. That submission, my lord, has been rejected by the division bench. And what the impugned order does, my lord, is what was the stale reasoning that we will lump everybody together and see whether minerals could be actually moved in a large quantity. The same reasoning has come to stay. And this, my lord, is really, it is not subserving the spirit of the order of the division bench. And this, your lordships will find, is, my lord, reflected in the order which my learned friend Mr. Singh, and my lord, here also on force majeure, it is cut, copy, paste. On force majeure, my lord, all of us have more or less similar, same annexures, same wordings, and same reasoning. And my lord, what is the reasoning? For anybody to be persuaded. My lord, the world GDP went by 4%. India's GDP sunk. My lord, in fact, iron ore, the steel production, even though it was exempt from COVID, still, my lord, steel production went down. This is the reality. My lord, we have taken a hit because of COVID. And for any government to say that COVID did not impact you, is, my lord, is being slightly glib and somewhat oblivious, shall we say, my lord, to the realities, which have been set out, my lord, at great length in the judgment of the division bench. My lord, it is admitted that there was capping of transport. It is admitted that there were restrictions. It is admitted that all was not equal. Now, my lord, is it an answer to say that somebody could actually move 1 lakh tons more and you moved it less? And that, my lord, was itself interdicted by this judgment. You had to consider the facts of an individual case with reference to that individual lessee. This, my lord, is the third point. And therefore, I submit, my lord, this is an alternative submission as far as force majeure is concerned. My lord, the Chief Justice was right. What we normally understand by force majeure is somewhat expanded in the definition which your lordship saw. It's a wide range of contingencies. But, my lord, I must show your lordships one document which is of importance. The central government pleaded with the state governments to apply force majeure in respect of mining leases. Your lordships will find this document, my lord. It is 5th of May 2020. It is at printed page 249 of your lordship's paper book. Please see this, my lord. This is Government of India saying, please apply force majeure. Your lordships will notice the date of this letter is 5th of May 2020.
Yes.
And it is, my lord, from the Ministry of Mines, Government of India, to Principal Secretaries, Commissioners of State Governments, invocation of force majeure clause in the mineral development and production agreements signed by the lessees and the state governments. I am directed to bring to kind notice about the unprecedented situation caused in the country due to countrywide lockdown done due to the COVID-19 pandemic. The mineral industry has brought to the attention of this ministry about the adverse impact of restrictions imposed on travel, transportation, on mineral production and demand. There is a demand from the industries to invoke the force majeure clause of mineral development and production agreements and to reassess the quantity of mineral to be produced considering the ground realities. The production can be increased when the situation normalizes. The said request of the industry appears considerable in the present situation. It is therefore suggested to consider such request of the leaseholders, taking into account the ground realities and give relaxation accordingly. Now, my lord, there is an advisory from the central government. There's an order of the division bench. My lord, it completely baffles one what is actually gained by the state government denying force majeure. But, my lord, what it gains is this. If it denies force majeure, it denies 12.1 GG and it proceeds straight to 12.1 HH and say everything is confiscated in the state. And that, my lord, these are the three impugned orders, my lord, in my case, that is Annexure 15, which is the impugned order, dated 5th of May 2021. Annexure 18.
No, Annexure 15 you are challenging.
Yes, my lord. Annexure 15 is the order.
Is the advisory which you are referring
No, my lord. That is a different. That is Annexure number. My lord, this is Annexure 20, my lord.
Annexure 20.
Yes. I'm challenging, my lord.
Oh, that is also 5/5/2020.
Yes.
5th of May.
Yes, 5th of May 2021, my lord. 2020.
No, that order is 5/5. That advisory is 5/5/2020.
20, my lord, but the impugned order.
2021.
Yes, that is, my lord, 6th of May 2021.
It is part of your representation.
That's right, my lord. After the representation.
Part of it.
Yes. Representation, my lord, is 29/12/2020. The impugned order is 6/5/21. Your lordship find?
All right. Exactly one. Yes.
It is, my lord, just about a year after that advisory, my lord, from the central government. So, my lord, I submit with the utmost respect. So, my lord, my submission for your lordship's consideration is that there has been a failure to appreciate or understand the intendment of section 8B1, 8B2, the terms of the lease deed, the letter of intent, and also, my lord, Rule 12.1 GG and 12.1 HH. And if the jurisdictional conditions, my lord, which are implicit in those rules, namely of severance of the old lessee from the leasehold area, is not satisfied in my case, then, my lord, there is no authority to decline a request under 12.1 GG or issue an order under 12.1 HH because they are not applicable. They are not attracted, my lord.
Yes.
My lord, I'm more than happy to any questions your lordships may have for me, my lord.
Thank you.
It was such a pleasure, my lord. I'm grateful, deeply grateful.
Yes. Can someone argue in the third category?
Lordship,
We have been
second
able to
category-
understand two categories.
Lordship, I'm in the second category. Lordship, I'll just take 5 minutes. I don't need to. And then I'm done. Ghanshyam Mishra, Lordship, a notice in para 3. There were two LSCs, Ghanshyam Mishra and Sir.
So he's
I'm
partly argued for you because he plays.
I'm going to, of
matters.
course, I'm going to adopt. That's the best thing I can do is to adopt the submission. Except one more thing, Lordship, allow me, I'll do that.
Yes. You are in which?
Lordship,
case?
that would be the sixth item, as I understand. Sub item 6. This
I'm sorry, I'm seeing you for the first time. What's
My name is Ramesh Singh, my lord. In the first round, I argued for Sirajuddin.
What is the case number?
Lordship, it's 18981 of 2021.
Yes.
Made with the Lordship. No, Lordship, on the larger issue, that 12.1 GG and HH does not apply. Of course, as I said, I'm fully adopting. And Mr. Subramanian's submission essentially was, the test was so severance. In my respectful submission, there is one more test and I'll just place that. And that is absence of obstruction. Lordship, the very object of 12.1 GG is to ensure that when the new lessee comes in, there is no obstruction.
It's like a rent agreement in respect of a flat.
Yes, well,
between the landlord and tenant, which may require that once the period is over,
yes,
you must remove your all the articles within a particular period. And if you don't, the landlord may acquire possession or whatever.
Take coercive action, whatever.
But your lease is extended. That is what.
Absolutely. So there is. Absolutely. So absence of.
If you don't remove, it cause obstruction to the new lessee.
Absolutely.
But since you are the lessee,
yes,
therefore that those provisions should not apply.
That makes sense. So therefore, the second test is absence of obstruction, and I leave it at that. Which is also forthcoming, Lordship. Lordship has been shown that 4th October 19 notification, that intermediate storage permission. Lordship knows that notification came in when none of us were aware that the COVID was going to come. COVID only hit us in March of 2020. That happened in October of 2019. And the reason was this, my Lordship has already noticed that in March of 2020, there was another extraordinary situation which was arising. All the leases were expiring. So, Lordship, there would be any other time in March of 2020, there'll be 24 lessees essentially who will be going out and 24 coming in. To take care of that extraordinary situation, this notification of 4th October 19. And if your Lordship may just have that, Lordship already, notification already been placed before my Lordship. You can just place that. 4th October, Lordship, which in my writ petition is page 43, annexure 2. That in my respectful submission actually shows the very same interpretation and understanding of the government. Extemporaneous exposition or contemporaneous exposition is the very same point. And it's very clear the very reason why they brought it out was because of this extraordinary situation which was contemplated in March 2020. And to do what? To avoid those obstructions. So that's my respectful submission. That's point number one, and I'm done with the first. The second thing, Lordship, which is peculiar to my case.
Just one
I'm so
question.
sorry, Lordship. I'm so sorry.
Did any of the lessees abide by that?
There were few people who actually made that application and they were granted.
No, granted, but did they, carry the thing to the alternative site?
Few of them, Lordship. In fact, one more matter I'm appearing. There's, in fact, perhaps I'll be making the submission. There's a third matter which I have Lal trades, Lordship. I'm so grateful. There I'll be making actually the submission which is falling from something on that line. I'm so grateful. So therefore, in this case, Lordship, the second submission is the subsequent development. What had happened in our case, Lordship, after this writ petition was filed, this is a subsequent development which has happened. And this perhaps, Lordship, if I learned it, Advocate General is standing up because things have moved after that.
He's sitting.
Yes, he's very much sitting here. And as the things have moved thereafter, as things have moved thereafter, perhaps, Lordship, in my case, the matter can be disposed of on that account itself. And what is that subsequent event is what I want to point out. Lordship, when these matters were filed, there was an interim arrangement which was made by my Lord predecessor bench, which is 29 October 2021. But just please that.
1 month time was
I'm
granted.
so Leadership was well aware. I'm so grateful. Leadership, I have put in an application, IA 18625. Essentially, my second submission is based on that IA. IA 18625 of 2020.
One. 21. Yes.
If my Lord make me kind enough to come to page 4, that's where I've quoted that order. Page 4 of that IA, para 6, my Lord. That order is 29th of October 2021. May I just place that?
Just a minute.
I'm so sorry, Lordship.
You are referring to?
Lordship, I'm referring to para 6, Lordship. It's at the bottom of page 4 of that IA. That when the writ petition was listed, I'm so sorry.
Page 4.
Page 4, my Lord, of that IA.
Yes.
IA 18625.
Yes.
Lordship, may see para 6, my Lord, is what?
Yes.
May I place that? When the writ petition was listed before this court on 29th of October 2021, this court was pleased to pass the following order. Next page, Lord. So after hearing the learned counsel for the parties, the following interim arrangement as agreed upon with the parties directed to be implemented. The petitioner will on before so-and-so apply to the authority of issuance of transit pass for removal of mine stock so-and-so, which expired on 31st March. The above application shall be processed by the authorities and transit passes shall be issued in accordance with law on before so-and-so for a period of 1 month thereafter, that is up to so-and-so, a corresponding date 1 month from the actual date of issuance of transit pass. The petitioner will be permitted to remove whatever stocks they're able to remove under 12(1) GG and so. Correct, Lord? So Lord, all of us, Lordship, post this interim arrangement, they remove their stocks. Now, in my case, what had happened, I was able to remove everything except 191,000 odd metric ton of subgrade. Now, why I was not able to remove that, Lordship, I kindly have para 7 of my application. Why I was not able to remove that. I removed everything except this subgrade of 191,814, which my Lordship will find the reasoning is of para 7 of my application. May I just place that?
Yes.
That the pursuant to the aforesaid order, the petitioner has been able to run stock of so-and-so, which were reflecting on online portal of the government, that is I3MS system as saleable. But it could not remove admitted stock of subgrade 4 of 191,000. The same was reflected in I3MS system, but not updated as sellable so-and-so. As a result, to the extent of so-and-so, it could not be made use of 30 days granted period for no fault of the petition. Correct, ma'am? And accordingly, Lordship, para 10, we indicated because that we could not dispatch it. That in light of the above, it is submitted that I3MS portal would have reflected the admitted quantity, then the petition would have been able to dispatch the same. So I was prevented because this problem on this on the portal itself. Lordship, there's an order that passed on this application of mine by my Lord on 12th of January 2022. My Lord may have in my paper book, 12th of January 2022. May I just place that order?
Yes.
My submission, I don't want to trouble. My submissions are recorded in first 3 paragraphs. My Lord may straight away come to the 5th paragraph. The then Advocate General reply. what I've already articulated, Lordship, is indicated is captured in first three paragraphs. My Lord may have paragraph 5 of that order.
Yes.
But in course of hearing, Mr. So-and-so, learned advocate general states that unless the subgrade ore is properly stacked and sampling done, follow-up action cannot be done by authority and so-and-so. Para 7. Needless to say that in the meantime, the petitioner approached the mining authority to indicate the stack size so-and-so. So we started this exercise on 6th of May. We were ready. We indicated to them. Now, Lordship, what had happened is cutting the whole thing short. We undertook the stacking exercise. They came and so forth, so on and forth. Now, I have put in a rejoinder, Lordship. What we have reached today, Lordship, I just wanted to indicate that in my rejoinder, the stage today, Lordship, 54 of my rejoinder, annexure 28. Where have we reached now after that whole exercise on this aspect, about this portal aspect? What we have reached, Lordship, is the recommendation of Director of Mines to the Secretary to do the needful. That was first made on 12th of December 2023. Page 54 of the rejoinder.
Four of the rejoinder.
Rejoinder. Annexure 28, page 54. 12th of December 2023. My Lord the Chief Justice.
It's not there. It's not been scanned.
Rejoinder to the counter by OP1. It is there, but where?
That's the one. Lordship, it was filed on 18th of September 2024. 18th of September.
No, but it's not numbered. Must be after that counter.
Which, no.
Right. There in the brief.
Seek an explanation. It has been stated. It appears from the cause list that a rejoinder affidavit has been filed on behalf of the petitioner to the counter affidavit filed on behalf of OP number 1. Full stop. Physical record है? हाँ? Physical record है? Page 375. Oh, but it is not scanned.
No, not page 1.
Seek an explanation from the registry as to why the said document has not been scanned. First off, the registrar general will submit a report in this regard.
Lordship, can we share the physical copy?
Chief Justice. Yes.
You can just share.
Yes, we cannot see that. All right, make your submission. We will see later.
Very well. Lordship, page 54. That's 12th of December.
These are application of them to see.
All the time they do this.
Yes.
So on 12th of December 2023, there is a recommendation then ultimately made by Director of Mines to the Secretary.
Oh, WBC होगा 89/189/81 of 2021. Yes.
Page 54, Lordship. I'll just place that. In writing a reference subject query of steel of mine dated so and so, I'm to state the following. The subgrade reject ode of 1,91,814 for which we are concerned. Of old lease had not reflected in monthly return in form F1 AA1 for the period of April 7 to March 20. And there was scope to show in the return, but the lessee has reflected the annual return of IBM and no dispatch has been made from the mines. There is a stock of closing balance of so and so. Iron ore after expiry of the license period of intermediate storage license, which expired on 22nd May 2023. Hence, it is requested to consider the representation Mr. Ghansa Mishra and Sons, that's me, my lord, ex-lessee, to allow the balance subgrade reject ore of 1,91,814 to enter into the books of account, that's the portal, my lord, and allow him 12 months to dispatch from the mines and renewal of the license for balance dispatch stock lying at the storage.
Just one.
I'm so sorry.
No, why is this happening?
That page marking they have not done. Our running page 568. कोटी काढ त्याला औषध काढले सॉरी जल्दी काढ सर सॉरी 99
Train them. Yes.
And also this recommendation which was made on 12th of December 2023,
which annexure is it, please?
that the one I placed my ladyship was annexure 28, page 54. Annexure 28, page 54 of my rejoinder.
Yeah, is it because of the vendor? Vendor. Vendor does it. Yes.
So this recommendation was made in December of 23 by Director of Mine to the Secretary. Nothing happened. I'm sorry.
Ulta page. Pages ulta.
452. Yes. Yes.
So Secretary of Mines then seemed to have done anything about it. So the recommendation was reiterated on 3rd of April 2024, which I have also placed with my rejoinder, 59.
Yes.
At page 56, annexure 29. So that recommendation again reiterated on 3rd April 2024. No, this is the position. I just wanted to cite, Lordship, in fact, this is the I3MS portal issue and therefore not being able to remove was also issue in the first round in one of the matter. So this was actually, this gained attention of the court in the first round as well. If my Lordship may have the judgment, judgment.
Bajrang Sharda and Khatau Narberam, it was allowed 45 days, right?
Absolutely. I just need to give paragraph. Leadership allow me, I'll just give paragraph and then para 79 and 80.
Yes.
Exactly. So this I3MS issue on principle was also dealt with and the state was directed to do the needful. I was given. And that's my discrepancy. I'm so great. That's my submission, Lordship. I'm so great.
Thank you.
Sub-item 2, my lord. Sub-item 2. I took it to address because he was the conduct. He was arguing the matter in the first round. In the second round, he wants to argue. So can it be possibly Mr. Rothgi?
In which matter?
Sub-item 2.
Yes, we are. Can hear it? Yes.
Sub-item 2.
Yes, we can hear him. Is he online?
So he's not in. So he had to request that it will be taken on Monday.
We can hear the other part instead of.
Manoj, Mr. Rodgi is leading me. He's reaching in like 10 minutes, Manoj. He'll join in 10 minutes, Manoj.
10 minutes, I'll complete your lectures.
Yes, Manoj.
You will take only 10 minutes.
Yes, sir. Why? Because
Are you sure?
Yes, Your Lordship.
All
Because
right.
my matter is very
Standing
similar to the first matter.
Okay.
And I don't intend to repeat. I don't intend to repeat any.
I'm sorry,
I think
my lord.
Mr. Rothgi is there. So,
Lord, my sincere apologies, my lord. I went for a special bench matter, but the moment I went, my lord, it got adjourned. So I've to do this.
Yes.
I'm very grateful, my lord, for your lordships accommodating me. I will be, my lord, as brief as possible because your lordships have been hearing this matter and your lordships have seen, my lord, all the notifications, all the provisions. But I'll tell your lordship, my lord, in brief what my case is. My lord, my case, my lord, is called KJS Aluwalia.
Yes.
This is, my lord, writ number 1353.
Yes.
Now, my lord, I am also a minor, my lord, in Odisha. And my lord, my lease came to an end on 31st of March 2020. Your lordship will recall, my lord, that officially, my lord, COVID started around 20th of March 2020. So, my lord, the expiry coincides, my lord, with the commencement of COVID. Now, I have, my lord, a large stock in the lease area, which is similar, my lord, in the case of three other miners. One is, my lord, RP Sao, one, my lord, is Sirajuddin, and one is, say, my lord, my client. We are in the range of over 5 million, more than 5 million, my lord, extracted material, all extracted prior to 31st March 20. There is no allegation here of, my lord, illegal mining beyond 31st March 20. Only question is, my lord, whether I should be given further time for renewal after FF, GG and HH, or I should not be given and the mineral will be forfeited in favor of the state. That's, my lord, the only question. Now, my lord, your lordship may note that as far as I am concerned, my lord, I came to the court in the first instance when, my lord, the earlier Chief Justice's bench sent the matter back, my lord, for the authority to decide whether really, my lord, a case for extension because of the conditions is made out or not. That has been decided now by the impugned order that you should not get any extension, and the secretary to the government who passed the order says that there is no case made out of force majeure because some other people took it out earlier, later, more efficient, etc. So you should not get any more. My lord, my earlier writ petition, my lord, was bearing number 2973 by 20. The earlier petition was 26973 by 20. Now, my lord, that was remanded. If your lordship will see, my lord, that order,
yes,
in my writ petition, that order, my lord, is at page. It starts at, my lord, 496.
Just a minute.
Yes.
Which page?
496. Not 496 at 501 it starts.
Which annexure is that?
My lord, this is
It's a 48.
48, my lord. I need to write it here.
Yes. Yes, we are there.
Yes. So, my lord, your lordship will find this is the does. My lord, my submission has been recorded in para 9, my lord.
Yes.
So and so submits that FF envisages exclusion in determining the period under GG. Opposite party is bound to consider the representation of the petitioner so as to examine whether any default has occurred on account of force majeure. FF, GG and HH are in pari materia with the form, that is not the form of the lease, mineral concession rules, where the lease is stipulated. So FF, GG and HH provide, my lord, and also the lease provides an intrinsic material that if there are, my lord, force majeure conditions, these conditions, my lord, cannot be put in a box. They can arise, my lord, in various situations. You can have a flood, you can have a drought, you can have an earthquake, you can have a volcano, you can have, my lord, a pandemic, you can have an outbreak of disease, so many things.
You can have a strike.
Sorry, my lord?
A strike.
Right.
There can be a strike also.
Like, I am grateful. Not the VC was not very clear.
Fire, explosion.
Yes. So there are, my lord, there
flood,
could be, yes. So there,
tidal wave, storm.
Correct. So there can be myriad reasons, my lord. That is very important. The authority has not understood.
Civil commotion.
So, my lord, civil commotion. We are talking about a pandemic, my lord, which has affected the world. And here is an authority. We say, no, doesn't matter. I'm amazed. We are, my lord, in a pandemic affecting the world. People were unable to move. Your lordships, my lord, no, we lawyers, judges, everybody was, my lord, in homes. We could not move, we could not talk. If that was the commotion of the world, he talks about civil commotion in an area, could be in a district. I'm talking about the whole world. So if that is the scope, my lord, if that is the concept which this world has faced in an unprecedented fashion, at least in our lives, I hope it doesn't come back again. But in our lives, my lord, if that was the situation, I am amazed, my lord, how the authority can put blinkers on their eyes and say, no, nothing has happened. So, my lord, these are the contentions, etc. Now, your lordship sees para 11. And I submit, my lord, this root of the matter. 11. Mr. So-and-so submits that spread of COVID-19 is devastating, has been acknowledged and recognized by the government as a force majeure. If government of India has recognized, my lord, the Supreme Court suspended the law of limitation. My lord, the Chief Justice, the lady judge would know. The Supreme Court suspended, my lord, the law of limitation by an order under Article 142 of the Constitution. My lord, that is an unprecedented step. Central government has done. Last line. Reference is made to various orders. Those orders are at page 512, my lord. So, Ministry of Finance says, my lord, under A, see the italics, my lord. Spread of corona as a natural calamity and force majeure. Ministry of Railways, my lord. It says demurrage won't apply. Ministry of Shipping, my lord. So why not Ministry of Mines? You have shipping, you have railways, you have, my lord, finance. The lordship will find, my lord, 513. Relaxation by indirect taxes. That is for containers. This is important, my lord. Relaxation in relation. Your chair here. Relaxation. Get him a small chair, please. From there. Relaxation in detention for containers. Then your lordship will find mines at subclause F at the foot. Kindly turn, my lord. Next page. This is for ground, paragraph 2, which is quoted, my lord. Quantity of to be reassessed considering ground realities. What are ground realities? You can't transport. I have already extracted. You don't have trucks. You don't have drivers. You don't have labor. You don't have, my lord, labor in a place where it will be carried. If this is the situation and there is, my lord, a logjam at either end, to say that everything is hunky-dory, my lord, I think strains credulity. Then, my lord, this goes on. This goes on, my lord. And, my lord, I cited a judgment, a celebrated judgment at 516, my lord. Mugniram Bangar's case.
Yes.
Bangar says, my lord, it need not be literally impossible, provided it is impracticable or not possible in the realistic sense. That is very, very important. I mean, it's not impossible, my lord, that you could get 100 drivers, but the point is, if the whole thing is in a logjam, then, my lord, nothing can be done. So all this, my lord, went on. And then, your lordship will find, and with great respect, my lord, this judgment of the Chief Justice takes great pains into going, my lord, into all this. And finally, my lord, it says, kindly, my lord, now turn para 77 at page 600. So in 76, my lord, actually, the court said that exercising judicial review, the state must apply their mind, and in 77, on the next page, middle of next page, my lord, that the order was passed without considering any arguments. The writs were partly allowed. The orders rejecting my representations were set aside. Matter was sent back, and
Yes.
then, my lord, in para 77, 77. We therefore allow the writs, etc. My lord, then it is sent back, place the material. So it is in this slide, my lord, that the matter went back. Now your lordship will have, my lord, a very brief look at what transpired, my lord, in the impugned order. The impugned order, my lord, is
Yes.
Is, my lord, annexure 2, page 126, 5/5/21 is the date of the order.
Yes.
And I submit, my lord, this order, though it is a speaking order, suffers from the same problem that he has not applied his mind, and I may state the point, has not applied his mind to the various notifications issued by the government of India, that there is, my lord, a force majeure. So, my lord, he has framed a question that is there a force majeure? Now, if the government of India has said in 20, my lord, notifications that there is a force majeure, how can you pose a question? It's like the chicken and egg story. How do you go back? If you pose the wrong question, you're going to get a wrong answer. My lord, the order starts at 126. Your lordship will find the questions posed. We turn to 142, my lord. Whether the contention at the foot, my lord, that the conditions owing to break of global pandemic resulting in restrictions was practically impossible to perform his obligation and therefore warranting, my lord, force majeure. I submit, my lord, this question is answered by Government of India. It is answered by Ministry of Mines, Finance, Road Transport, Railways, and every other ministry. This was not a correct question. The question was, if it is force majeure, to what extent, if any, relief should be available? That should have been the question. And your lordship will remember, my lord, that certain orders of the Supreme Court are already here. Your lordship may note the names of those cases. I had the opportunity to appear in some of them. My lord, the names of those cases, which I will show, one is Chaugle, my lord. Your lordship will note Chaugle 1, Chaugle 2. And the third.
Those judgments have been too.
Yes, yes. So Chaugle 1, Chaugle 2, my lord, and Mid-East. And Mid-East, my lord, got several extensions. That's very, very important. My lord remembers, my lord, Mid-East got 2 months, then 4 months, then, my lord, 6 months. So a total of 1 year. And Mid-East was a case, my lord, where their mining was closed. Please make a note, it's important, my lord, on Mid-East. I will not refer to it again. Mid-East. My lord, Mid-East was asked to suspend mining with effect from 1/1/18 because of defaults, my lord. They owed hundreds of crores to Government of India. So Mid-East was allowed to remove material, sell it and pay Government of India. And they paid also. So, my lord, Mid-East got 2 months, 4 months, 6 months.
But they got from Supreme Court. So,
my lord, with great respect, my lord, with great humility. My lord, the Supreme Court is hearing an appeal against an order under Article 226, my lord. The powers exercised, my lord, by 136 are really, my lord, with all humility I submit to you. The powers exercised by 136, my lord, in an appeal against 226 are the same.
No, there you are correct. There you are correct, Mr. Rotegi. But while exercising power under 136, the Supreme Court also is the power under 142.
I am very grateful. But, my lord, I can only share my experience, my lord, of 40 years in the Supreme Court. When their lordships exercise power under 142, they make it plain, my lord, that we are exercising power under 142. If necessary, I will file 50 orders tomorrow, my lord. Even short orders, my lord, their lordships say that 142 we are exercising to do complete justice, etc., etc.
So your submission is that since in those orders,
my lord,
there is no mention of article mention.
Absolutely.
Those orders, therefore, all right.
My lord, there is no mention, and the Supreme Court was exercising its appellate jurisdiction, relying upon the notifications of the Government of India that there is a force majeure and therefore people are entitled to breathing time a little more or little less. Because, my lord, I am the owner. It is not that I am grabbing somebody's property, my lord, I am the owner. Should I get some more time to take away my goods? What's the prejudice to the government?
But is it also not a duty of the High Court to find out whether a particular order has been passed by the Supreme Court in exercise of its
Undoubtedly, my lord, undoubtedly. So we can't now sit in the mind of the court, my lord. We can only go by the written letter. Now the written letter, my lord, nowhere makes a reference. And, my lord, there are so many orders. Chowgule 1, Chowgule 2, Mid-East, then, my lord, other orders. So please take it, my lord, there is no case of 142. And, my lord, I may indicate right now, the order of the Supreme Court, my lord, extending limitation. I will place it before your lordships. The order, kindly note that, my lord, I will have it passed on. The order of the Supreme Court suspending the law of limitation. An order, my lord, under 142. Otherwise, such an order could not have been passed. And as the lordships know, my lord, 142 is never applied, my lord, in supplanting the law. 142 is applied, my lord, where the law does not have a positive prescription. And therefore, my lord, something can be done. I can give you lordships, my lord, if I may say a nearer example today morning. You know, your lordship will read, just a 1 minute aside, your lordship will read in the papers tomorrow, there was some, my lord, issue of a Madras High Court order, my lord, a foundation of Sadhguru, Mr. Sadhguru, called Isha Foundation. The High Court passed some order, my lord, today. I mentioned that matter, my lord, to the Chief Justice today with an SLP. Their lordships, my lord, it's an SLP. Their lordships, my lord, passed certain orders withdrawing the writ itself from the High Court. I had never prayed for that, my lord. There was no transfer petition. Whether it was under, I don't know, my lord, those are extraordinary orders. But this was an order in appeal, my lord, with great respect. It is not as if these are 142 orders at all, is my respectful submission, my lord. So, if the Supreme Court, my lord, has seen the realities and the ground realities and granted, there is no reason why, my lord, an owner should not be allowed to take away his material, which is worth more than 500 crores, my lord. I have suffered, my lord, because 4 years or 3 years have gone by from 20, we are in 24. My material has deteriorated. It has gone through 4 seasons of rains, my lord. And that is how, my lord, I should be able to look at this. Now, my lord, have a look at, I will read 142. It's a wrong question. And what the court does is, my lord, what the secretary does is, he goes on, my lord.
Yes.
The secretary, my lord, goes on irrelevant issues, my lord. For example, my lord, at 147, your lordship will see it's an irrelevant issue. At 147, there was an issue, my lord, that there, if your lordship sees para 31, I may explain.
Yes.
There was a notification, my lord, of 4/10/19 before, my lord, the expiry of the lease on 31st March, nobody knew about COVID. The notification said that if you can transport your material from time to time and store it outside if you fulfill certain requirements. Now, this came, my lord, on 4/10/19, only 5 months before. So he's saying, why didn't you, my lord, take advantage? You could have taken it out in 5 months. My lord, we gave an answer that by the time I got the permission, my lord, it was March 20 itself. That he doesn't write here. I got permission in March 20. How can I take it out by March 31st March? I had identified a plot where I will take some material which is at the bottom of 147. I had taken that plot, my lord. I required a license. They gave me a license, my lord, only in middle of March. So I said, my lord, I can't do it. So he says, oh, we gave you an opportunity. You didn't do it. So sorry, you must be to blame. That's not the point. The point is, my lord, the practical situation post 31st March 20. That's the first error. Then, my lord, your lordship sees 32. Again an error. 32, my lord, there was a policy of the government that if you don't want stacking sampling, where, my lord, the inspector will come, he will look at stacks and all that. If you don't want that, you can apply for an exemption from that policy. And you can remove all the ore by paying the highest level of royalty. Whether the ore is good or whether the ore is bad, you suffer higher money, but have, my lord, smooth removal. I was doing it, but most of my ore on that day was low material, low quality. So I said, I don't want that exemption. So he said, if you don't want that exemption, you didn't want the removal. If you didn't want the removal, then you are to blame. It's a completely irrelevant issue, my lord. Both these issues are irrelevant. And it's here. Yes. So, my lord, it's actually irrelevant. Then, my lord, refers. He see 149 bottom. He refers, my lord. This is, my lord, absolutely perverse. See, this is perversity. Para 34. State government has taken a conscious decision to permit mining. As such, there is no prohibition in mining or transportation during the lockdown period. What is my friend talking about, my lord? If you couldn't drive a car, you couldn't meet anybody. Could I have 5,000 trucks, my lord, which are required for evacuation? He says state government didn't do anything, so there is no problem. My lord, you can't have blinkers in your eyes. Problem is facing us in the whole country. Your lordship now sees, my lord, now 35. That every paragraph is erroneous. 35, my lord. He says, I will examine some statistics. So he calls from statistics, my lord, from the government without, my lord, any copy to us. No opportunity to us. So he says, when I've got the statistics, my lord, he says, many people have removed. So why did you not remove? That is again not the question. And the problem is, kindly turn to 36, my lord. In 36, my lord, he refers to some lessees who were able to remove more, and that is at 37, my lord. 37. He compares me in para 37 to a company called Rungta, my lord. My lord gets that name, Rungta.
This point was argued, Mr. Rohtagi, in detail.
Right. So, my lord, just note that Rungta has, my lord, a railway siding.
Yes.
He doesn't require 5,000 trucks a day. You can't compare apples and oranges, my lord. Then he goes on and on. And then he says, now 44. This is an inversion of the law of equality. He says, if I give you force majeure, it will mean that I am treating equal place lessees as unequals. I don't know how, my lord. Everybody before your lordship is wanting the benefit. Which lessee is saying, I don't want the benefit? Look at para 44. Absolutely, my lord, inverse reasoning. And then, my lord, he says, my lord, at the foot of 156, my lord, there is no justification, and that's the end of the matter. So, my lord, with great respect, you will not address the correct question. that if there is force majeure from Government of India and as a matter of common knowledge, then obviously we should have been granted, my lord, some breathing time. Now, my lord, your lordship may only note, as far as I am concerned, my lord, my lease expired on 31st March 20. So I have 6 months, my lord, from 1/4/20, which expired, my lord, on 30th September 20. In this writ petition, by an interim order, dated, your lordship may note, my lord, dated 8/11/21, I was given ad hoc 1 month, which would expire, my lord. It would expire, my lord, from 20. It would expire. It would expire, my lord, on 22nd December 21. And then, my lord, the question was kept open to be decided today. So, my lord, it is very important to note that in one order of the Supreme Court has referred to the fact, my lord, that these lessees are the owners. And there is no reason why they should not be allowed to remove. That is what I wish to, my lord, point out. Only that line, my lord, your lordships have seen those orders. Only that line, my lord, that they are owners. Is it in this or mid east? Chogle 1. Okay, I've got Chogle 1. My lord, do your lordships have Chogle 1 or may I just read out that line?
Yes, please.
My lord, kindly note para 35 of Chogle 1. Last line of para 35, my lord, kindly make a note. There is no doubt that the ownership of the oar is that of the party which has raised the oar. The oar which will be permitted to be transported is on the condition of payment of royalty. Same here. We see no reason why the owner should not be allowed to transport their own oar. This is as clear as, my lord, daylight. That given, my lord, these practicalities, you give some more time to a man to take away his material, and the last issue will be, my lord, in this state of affairs, for the state to say, my lord, I should swallow all the oar of these parties, my lord, will be unjust and will amount to unjust enrichment. Therefore, my lord, we should be allowed to remove our oar, and your lordships can record that the new lessee, in my case, is a company called JSW, one of the largest miners in India, my lord. And they have no objection, my lord, if I remove my oar, which is today lying, my lord, in the leased premises, provided I do not cause any trouble for them, which I undertake, my lord, I will not cause any trouble. I should be given, my lord, as the Supreme Court gave in Mid-East, a period of 6 months, my lord, from today, so that I remove whatever I can, and then, my lord, be done with it. And I dare say, my lord, your lordships, my lord, would consider also, let all these miners, my lord, pay a kind of cost, my lord, to the legal aid authorities or to the state government or to the Chief Minister's fund of a sum, my lord, which your lordship may consider. So that sum, my lord, these people also shell out some money. Could be a sum of 50 lakhs, could be a sum of 1 crore. I am willing, my lord, your lordship
Very low,
may say 1
Mr.
Sorry, my lord.
50 lakh, 1 crore is nothing.
All right, your lordship may make it 5 crores. Lordship may record my statement insofar as my client is concerned. He is sitting before me. I will deposit 5 crores in any fund, your lordship may say, without prejudice to our case, my lord, that we were not guilty at all. The lordships, my lord, will say, we shall deposit as a precondition. And now, one more thing, my lord, your lordship may note. Though I don't want to say anything, my lord, to the detriment of 136, but your lordship may note. 226, my lord, according to me, is wider because it includes, my lord, original jurisdiction. It includes a jurisdiction, my lord, which is also appellate or revisional at times when it is directed against, my lord, an order of an inferior court.
No,
or
we
tribunal.
have, Mr. Rohtagi, we have no doubts about that.
And my lord, 136.
The powers of the High Court under Article 226 are wider.
Very wide. Now, my lord, the importance is this, that 136, my lord, is an appellate power.
Yes.
136, my lord, is not, my lord, an original power. The original power is in 32.
Right.
Therefore, the Supreme Court, yes, exercises, my lord, appellate jurisdiction.
Right, Mr. You are right.
So, my lord, your lordship may take it, my lord. In none of these cases has the Supreme Court, my lord, said anything
Mr.
about
Rohtagi,
142.
Mr. Rohtagi,
And, my lord, your lordship may note.
Rohtagi, High Court has all the powers.
Yes.
To issue directions except Article 142.
I agree, but my lord, I want to tell your lordship, my lord, in that order where the Supreme Court suspended limitation, my lord, can I screen share that order?
We are aware, Mr. Rohtagi, those proceedings.
Correct. No, my lord, that order is, yes, my lord, this is an order. Yes, it is dated 27th April 21. And my lord, I will just read that part. I'll pass it on. I'll have it physically sent. The last para records, my lord, we have passed this order in exercise of our power under Article 142. Read with 141, it will be binding on all courts or tribunals. This order will be brought to the notice of all high courts, subordinate tribunals, etc., etc. This is the exercise of 141, or 142. This is our case, is not with great respect, with greatest respect, is one mundane case, my lord, which your lordship decides, my lord, every day, and which goes to the Supreme Court every day. It's not something so great, my lord. That is some very extraordinary case. It's a case where whether we should get a few months or not a few months is the only question. Therefore, in law, whether some of this period should be excluded from the regimentation, my lord, of FF, GG and HH is the only question. In other words, it's a question, my lord, something, my lord, akin to either condemnation of delay in Section 5 or better, to exclusion of time under Section 14 of the Limitation Act. That is for not wrong remedy. When you go to a wrong remedy, your lordship exclude that time. This is a case of exclusion. It doesn't require any emergency power or some urgency or extreme power by any court, my lord.
Yes.
It is the lordship's, my lord, normal power to construe extension or exclusion ought to be granted in the working of FF, GG and HH, or, my lord, in the terms of the statutory leaves in Form K under the MC rules of 1960. So I submit, my lord, subject to 5 crores, your lordship may consider our request, my lord, and my lord, relieve us of this case, my lord. That, my lord, is my respectful submission. I am very grateful.
Thank you.
I am very, very grateful.
My lord, I appear in this case for JSW.
Yes.
I am the pro forma OP number 7. I am the new lessee.
You are the new lessee in this
I am
case?
the new lessee, my lord. I am JSW, pro forma OP number 7.
So you want the O to be removed or you want to
I want my area to be free. But I want my area to be free. I'll just take down a few things, my lord.
thinking you want to buy the O.
I don't know. It's for them to do whatever they want. My lord, this lease was presented to me on 27th of June 2020. That is one date my lords may kindly note, my lords. And I got this lease paying a heavy premium.
the total area is, my lord, 777 hectares, 777 hectares. And the ore is scattered over an area of 84 hectares. And this 84 hectares in the mineral.
You have been implemented party in this.
Yes, I have been implemented as pro forma OP number 7. Now, my lord, my difficulty is I am causing hindrance being caused to me to carry out my mining operation. So, my lord, my submission is very simple. Let them remove the ore. Whoever takes it is not my problem.
So therefore, Mr. Rohtagi was submitting.
Yes.
That
And he
TQJC does not have any objection.
As, my lord, I can't have any objection because it is not my ore. I am only saying that please take it away and don't create any hindrance to my working.
That you can start.
Because the minutes, I have an obligation of producing X amount of MDPA, your lordship knows. So therefore, while you're taking it away, don't create a hindrance for me. And please take it because 4 years I have already suffered this material. And it is causing enormous amount of inconvenience to me. That's all minutes. I will give a 1-page note if your lordship don't.
In fact, in reply to my landlord petition.
Let him. Mr. Advocate General is on legs.
Yes. It is neither Mr. Rohtagi's board nor Mr. Parijat.
No.
It's for public court. So I'll address it.
Yes. Madam, sir.
Only answer, my lord. My landlord submitted that the necessary cooperation to be required. I filed an affidavit in pursuance to that I filed. I am for the 2.
Mr. Rohtagi.
Yes.
So there, they in fact wanted a shifting of material in the year.
No, we will see. Everything will depend on what opinion do we form finally.
Right.
So once Mr. Advocate General addresses, then if required, you may argue.
One more matter, the third category. I can address. I think I'll be done with it.
Junior most senior has the first right.
We had made her an offer that we made the junior most senior. We had made her an offer.
Junior most senior has the first right, Mr. Now.
No, that's all right. I'm just saying whenever she finishes, then whenever.
Lordships, I'm in the third submatter.
WPC?
That will be WPC 18019 of 2021.
Yes. So,
and your
all in which category?
My matter is with the first category and also which my senior Mr. Rohtagi argued. I fall in that same category.
Okay. Mr. Rohtagi, all right. Yes.
The first matter which was argued by Mr. Singh, we fall in the same category. Yes. So, Lordships, I will not repeat anything. I'll come to my specifics of my case. Your Lordships, may I just take your Lordships first to just page number 6 of my...
Just a minute. Let me open the brief first. 8019. Yes, which page?
Page 6 of my writ application.
Oh. Yes.
Lordship, there's a small table there in that page. Your Lordships, from April to October 2019, I had transported some 7 lakhs odd materials. That this is my statistics for the year of 2019. In April to October 2020, I could only manage to do somewhere 2 lakhs something. This almost comes to 3 lakhs, we may say, 3 lakhs metric ton. And if I make a differential of the transportation which has happened in both the years, it's comes about 4 lakhs something. And that's almost exactly the amount which was waiting at my site to be disposed of. And for me to transport it. Now, your Lordships, why I point out this statistics is because one of the grounds to reject me was this, and which is, I think, common. I think the wordings are common throughout everywhere. It was this, that there was a notification dated that 4/10/2019, and you should have availed it. So 4/10/2019, I from my past progress, I knew that I would be able to dispose of everything by March. Or sorry, by the within that 6 months period. So therefore, I correctly did not avail that. So you cannot hold it against me. So that would be one of my points. And your lordships, there's one more point that they have held against me, and which is also common, is that there were restrictions only to take it to the port. But the materials that I have are fine dust, which are only of export quality. So this did hit me. So if you say that, we only had restrictions for the trucks till the port, and you don't understand the nature of my material. So, I mean, that is again perverse, and you're just passing common orders. Then, your lordships, the para 68 and 70 of the impugned order, which is the detail order. Again, your lordships, there is a comparison with those Rumta mines and other mines. Now, your lordships, there are various variables. A particular mine owner may have a dedicated industry already. And that's also why they have these railway sidings. So it's easy for them to carry it. But people who are actually looking for floating buyers may not have that. So we are all not equally placed as far as circumstances was concerned. So therefore, this kind of observation is also perverse. Your lordships, with that, I'll just point out a few statistics, and I think that's peculiar for my case also. If your lordships, I can take your lordships to page 160 of the brief.
Yes.
Actually, the relevant page would be 163. It's the same annexures, your lordships, which I think Mr. Singh also had pointed out. Just page 163.
Yes.
Now, your lordships will find there's a chart saying month-wise number of iron ore trips dispatched within the country. Right bottom.
Yes.
And if your lordships will compare the 2019 data with the 2020 data, there was a sharp decline, almost half or less than half also, for the month of April, May, and June. And this is the period also, if this 3 months is provided to me, I can dispose of my 4 lakhs.
Yes.
And then, your lordships, I would just point out page 389, 390. Which are series of notifications by the central government. I think one of them has already been placed, if I am correct.
5th May.
I will, yes, 5th. No, there are another one, April notification and May notification, which does hold that period as a period of force measure, and that how we have to be liberal at various aspects. And one of them was, may I just read this, your lordships. I'm directed to bring them the notice about the unprecedented situation caused in the country due to countrywide lockdown done due to the COVID-19 pandemic. The mineral industries has been brought to an attention of the ministry about the adverse impact of the restrictions imposed on travel and transportation on mineral productions and demand. There is a demand from the industries to invoke the force majeure clause of the Mineral Development and Production Agreement and to reassess the quantity of minerals to be produced considering the ground realities. The productions can be increased when the situation normalizes. Now, obviously, they are not good. There are, because your lordships, there is a restrictions in these that you have to maintain a certain amount of production. So you are reducing the production because obviously your storage area will otherwise take the burden. And obviously, because you cannot transport and you don't have buyers. So I don't see how we are different here. So that's one thing that we like to point out. And your lordships, all that we are trying to say is this, that the entire period of 6 months is where the force measure clause is what we are submitting. and that additional 1 month. So the statute already provides me that right. All that we are asking your lordships to see is this, that whether the state has taken a correct position in denying us that right. So I think if we are seeking something within the statute, so there the difference of 142 probably would not apply. That's all will be my submission.
My lord, in this case, I'm appearing.
Mr. Singh. So, you are in which matter?
I mean, today, item number 4, I think sub-item 4 is for Lal. I'll give the writ petition number.
18743.
18743 of 21.
18743
of 2021. Lal Trades.
2021.
2021.
Any distinguishing feature? 18743.
Was the party here in this court in the last?
I'll tell you, it's very interesting. They were not the party to the divisional judgment, but their subsequent judgment relying upon division, that they were a party. So effectively, we were a party. So this was like the first round for me, was not 2020, it was 2021. That was the first round for me. Yeah, Lordship, this case is a bit peculiar in the sense, of course, one point is, which is a point only which I'm agitating, in addition to other points which I may argue. Lordship has been shown section 86. That's where the 31st March 2020 comes in. And if all these lease 23, 24, they're expiring, or the lease period expiring on 31st March 2020 by virtue of 86 of MMDR. Now, I'm sorry. Now, Lordship, 86 also provides for is 31st March 2020 or a period of 50 years from the grant, whichever is later. I fall into that second category. So in my lease did not expire on 31st March 2020, expired on 26th May 2020. So that's just the picture. Now what had happened? So when all this COVID thing happened, so I did two things, my lord. A, I made a representation on the GG and HS lots, like every lessee, for the extension of the period beyond the 6-month period. That's one thing I did. At the same time, Lordship, what I did, Lordship, at the same time, I also made an application under the notification of October 19, intermediate storage. Correct. I did these two things. Now, what had happened, Lordship, my application for intermediate storage permission was ultimately rejected by the government. And that happened on 9th of December 2020. And the ground was that you are not a March 2020 lessee, if I may just use that term. You are a May 2022 lessee. And that intermediate storage permission notification is concerned with March 2020 and not May 2022. That's the distinction the government made and rejected my intermediate storage permission.
So saying we'll have to rise because...
I can, whenever Lordship next, I'll take 15 minutes. Lordship, just permit me to do my submission, maybe on VC if I'm not physically present.
All right.
I'll be very grateful, Lordship.
We have a meeting.
Lordship rises. Small prayer, Lord. Item number 48. The last item, that is WPC 244.
Yes, we do remember. Sorry. What do you want? We do remember that.
There's no, this is a fresh matter. And there's no interim order, unlike other matters. There's 168A matters. The 168A matters.
48. In 48, you have a fresh matter.
I have a fresh matter. There's a last matter. There's no interim order.
All right.
The measure somebody not.
Give your slip.
Can it be listed on Monday or?
It has not been listed.
Lordship, item number 15 also same, Lordship.
Just give your slip. Just.
Lordship, item number 15 also same, Lordship.
Pass on the similar order which has been passed.
We will be passing on Monday.
Lordship, item number 15 also same, Mr. Same, Lordship. It is a fresh matter.
We know.
I think we should not.
Entire matter may be.
The last matter.
This would come on Monday. This would come on Monday.
This will come on Monday.
This will come
at 2 p.m.
Very well.
We could try to conclude the hearing.
My humble submission will subject to your lordship's kind consideration. Your lordship would be pleased, so please not can pass the similar matter.
Let it come on Monday.
The last matter, I'll give
Monday, just make a mention if it is not likely to be taken up on Monday. You just make a mention in the morning.
At 10:30, I'll make a mention.
Item 32 point, my lord, interim order should continue because day-to-day order. Interim order.
Don't worry, since we are not passing any order.
Deeply.
Yes, Mr. Acharya, we would like to know from you, when you make your submissions, please address us on the purpose of 12(1) GG and HH.
I will address on that. Not I have
Because,
taken note of the entire argument of Mr. Subramanian. I will address on that.
We are trying to understand that.
But this
That
same-
for what purpose the provision is there,
I will address.
and what purpose does it do they serve?
For these purposes, we have filed a counter affidavit in Alolua case, my lord. In case KHS Alolua, the government of India has filed. They made a party union of India, and we have filed the counter, my lord. Let me peruse it on Monday.
You are supporting whom?
We are supporting the state because on 12(1) HH, these properties belong to state, basically
All right,
the government of India, my lord.
All right,
Deeply.
Grateful minutes.